into the task that has been placed before us. So this is why we have set aside some part of our public engagement to interface very directly with those categories of persons. This would be, either academics, practitioners in a particular sector, institutions that are affected by or work in that sector, persons who have held office, public office in that sector, and who, by virtue of their insider experience, have something that we on the outside would not have the benefit of in terms of knowledge. So we are very grateful that you have essentially offered yourselves to assist us with the knowledge and expertise that you have. It is the Lands and Natural Resources cluster is the first of our public engagements. There is some logic to it. I mean, it's not. It doesn't mean that it is. There's a bit of a logic to the ranking, but I think it's also important that we start here. This being Ghana, a resource-rich country, and when we talk about development, that's really what provides oftentimes the base in terms of revenue capacity as a country. The natural resources are also very topical these days in the news around Galamsey and other issues. So I think it's important that we focus on that as well. But we also have sequenced these discussions in part looking at, we're starting with those provisions of the Constitution that those chapters where there are more non-entrenched clauses than entrenched clauses, right? So we want to get a sense of the scope of the reform possibilities in that particular area. So lands and natural resources happens to be one of those areas. So we are very glad that you are going to be able to share your knowledge and expertise with us on this. So on that note, going by my immediate left now, displacing Charlotte, who was to the immediate left, is Alhaji Ibrahim Tanko, a member of the committee. By my schedule, we have Professor Kwame Jan as the first stakeholder for today. He will introduce himself briefly and then proceed to make a presentation to the committee and for the benefit of the entire audience here. Thank you very much.
Mr. Chairman, distinguished members of this very important committee, the most learned Attorney General, former Attorney General, who is my senior at the bar, so I am 35 years at the bar. So if the Attorney General is my senior, it means he is very senior, so, so you see, so he is 9 years my senior, and that's the beauty of the profession. Mr. Chairman, I will want to say a few things about our Constitution and how it affects or how it is affected by the land sector. I don't have a paper. I just have notes I have scribbled. If we go back to the Constitution, we have lands and natural resources in Chapter 21. And it's not too many articles, it's 257 to 269. So it starts from talking about the definition of public lands and concludes with the establishment of commissions for natural resources other than land. Mr. Chairman mentioned our land. as very important. It is. We have a total land mass enclosed in our boundaries of about 238,000 square kilometers. And as all of us know, bounded in the north by the Republic of Burkina Faso, south by the Gulf of Guinea, east by Togo, and west by Cote d'Ivoire. And that's us, Ghana. At the time of independence in 1957, Ghana's population was below 6 million. And currently, we probably are in the region of about 35 million. So if there is anything that we have to take seriously as a country, it is the management of our land resource. The framers of the Constitution, you wouldn't fault them, because hindsight may be wrong, but it is because we have the benefit of the development since they put together this Constitution. The parameters in which the constitutional provisions on the land sector were set revolved around the Lands Commission. So in 258, the Lands Commission specifically is established with its mandate and its composition and powers and independence. All of that was set out. But for the other institutions, we didn't have that broad conversation in the Constitution. So if you go to Article 2672, it says there would be established an office of the administrator of stool lands. And then 2676 tells us about the mandate of the administrator of stool lands. And it gives you in 6 what we call the disbursement formula for stool land revenues. I'll come to that part. The disbursement formula for stool land revenues. Then in 269, reference is made to Parliament setting up within 6 months of the coming into force of the Constitution other natural resource commissions, and some were mentioned: forestry, minerals, fisheries, and others as will be determined by Parliament. Then 268 gives Parliament the power to ratify contracts for the exploitation of natural resources. And there is also power of Parliament to waive or grant that power to another institution. They've never granted that power to anybody, because it's a very important power, particularly if you are ratifying timber concessions and mineral concessions. And I've seen it. If you have a large-scale mining concession and you want to go through Parliament for ratification, it's, I believe I'm carrying my academic freedom here. I mean, no. It's the former Attorney General, he knows about it, because I think that he collaborated with the Minister for Lands to send a couple of concession agreements for ratification. And he knows what it is, and the reason why Parliament will not let any other institution do that. But let's flag a deficiency in 268. The framers of the Constitution did not indicate the consequences of a non-compliance. So Parliament shall ratify. All contracts for the exploitation of natural resources would require parliamentary ratification. But the Constitution did not say what happens. So there is a prohibition. But there is no statement on the consequences of a violation of the provision. And in this situation, given the uncertainties with interpretation by our Supreme Court, I will implore this committee, where it is possible, avoid a possibility to go for interpretation. You should be as clear as possible, leaving no doubt or minimum doubt for interpretation. I'm not saying that you can avoid interpretation, but wherever there is going to be any prohibition attached to the prohibition, a clear consequence for a violation. And this is not the only place in chapter 21. If you go to Article 266(1) of the Constitution, where there is a clear prohibition of freeholds in favor of non-citizens. Clear. 266 sets out the consequences of a violation. So we are clear that if you purport to create a freehold in favor of a non-citizen, the attempt itself becomes a nullity. But if you go to 266(4), which restricts the creation of leases not exceeding 50 years for non-citizens, there is no consequence. There's no consequence. There is a similar thing in 2675, where there is some restriction which is very controversial and unclear. That whole 267+5, that restriction on the creation of freehold interest in stool land, leaves a lot of doubts about its interpretation. We have not had a judicial interpretation, but in the preparation of the Land Act, Act 1036, in Section 9 of the Land Act, we introduced our own interpretation of 2675, which probably may be wrong. But I'll come to that if I have time. So 2675 says, don't create a freehold interest in stool land, howsoever described. No consequences. So if I create a freehold in stool land, what happens? So those specifics, we should look at them. Now let me go back to some of the more controversial issues. When we talk about a natural resource, 3 issues come up for consideration. 1, the ownership of the resource. The ownership of the resource. 2, depending upon the type of ownership, how do you share the benefits accruing from the exploitation of the resource? So benefit sharing. So ownership, benefit sharing. And finally, depending upon the nature of the ownership, the management of the resource. So ownership, management, and, ownership, benefit sharing, and management. Now, let's go back to our natural resources. At the time of the promulgation and the conversations on this constitution, we didn't have oil. So there is not a single word or phrase about oil in chapter 21. When it comes to forests, the only reference is the establishment of the Forestry Commission in Article 269. That's it. Fisheries, the same, only in 269, nothing else. Minerals, in Article 2576, we are told that ownership of minerals in our land, our exclusive economic zone, our territorial sea, and all the water bodies is vested in the Republic to be held in trust by the president in the Constitution. For the other natural resources, the Constitution is silent on them. So where we are, we have the option of taking out the mineral ownership part from the Constitution and letting the enabling legislations for the respective minerals deal with the ownership, or the ownership should be introduced in the Constitution for all the other resources. So, for example, if you look at petroleum, the Petroleum Exploration and Production Law Act 2016, Act 919, vests ownership of petroleum in the Republic. Now, the Minerals and Mining Act 2006, Act 703, also vests ownership of minerals in the Republic. In fact, what they do with Act 703 is to verbatim reproduce the provision in Article 257, Clause 6. Just bam, they take it from the Constitution and put it in the Minerals Act. So what we could do, either we take out the definition of minerals, the ownership of minerals in the Constitution and put it in an enabling legislation, like the other resources. And the interesting thing is, when it comes to forest, there is an old legislation, not too well known. It's called Cap 157, the Forest Act, Cap 157 of 1927. The Forest Act, Cap 157 of 1927. Now, Cap 157 says, where land is constituted into a reserve, the constitution of land into a reserve does not change the underlying ownership of the land. So it means that all the forest reserves, the lands are still owned by the pre-reservation owners. Most people in this country think that the forest reserves, the lands on which the reservations are sitting, belong to the state. They are not state lands. They belong to the same entities that own the lands before the reservation. So in Cap 157, it says the lands which has been turned into a reserve can be managed by the landowners under the supervision of government, or managed by government on behalf of the landowners. So you see what I was talking about, the management of the resource. So when it comes to forest, there are plenty of forest reserves in the country. And if you look at the way the reserves were constituted, the reservations were done primarily for the protection of watershed and the conservation of mineralized lands. You'll be surprised. All the areas that were reserved had minerals. And these colonial guys had very good reasons for taking beyond our reach those areas. So they made provision for the ownership of those lands to be preserved even during reservation, and for the possibility that the owners could manage under the supervision of government through the Forestry Commission, or government manage on their behalf. So when you look at the benefit sharing, what do the people get? The fringe communities, the people who were the owners of the lands before the reservation, what do they get? So you want them to protect a resource out of which they get virtually nothing. And this was one of the areas that led us into the Galamsey. Because the owner of the mineral is the Republic. And all of us here I don't know which of us, including my brother, the professor, has seen the Republic before. Madam, have you seen the Republic of Ghana before? He's the owner of all the minerals in the 238,000 square kilometers and beyond into 200 nautical miles of exclusive economic zone. Have you seen the Republic before? So who protects the minerals for an owner we don't know? So when we were failing in the management of the resources, what some of us were asking is, have we attempted to go back to the table on the ownership of the resource and how we share the benefits accruing from the exploitation of these resources? And here, the Constitution was silent. The two critical components, the management and the benefit sharing, the Constitution has been silent. When it comes to ownership, only in the mineral side, the Constitution says something. The rest, the Constitution says nothing. So we need to look at what prevails elsewhere. In the United States, if minerals are found or oil is found in your land, it's yours. You will do your own exploitation and the state will tax it. Maybe we don't have that system, the structures that can manage that system. But it's been done elsewhere. Here, the state became the owner of the resources so that the state would exploit and use it to develop for all of us. So as we put together the revisions to our Constitution, let's ask ourselves, has the stewardship of the state been commendable? If the state stewardship has not been commendable, should we put some words and phrases in the Constitution to deal with this? Should we actually continue this ownership? Was it not informed by socialist tendencies in a certain era? We should be dispassionate about these matters, Mr. Chairman. Then there are particular things we have to do. I'll take you back to a particular office in the Constitution. The office of the administrator of stool lands. This office is provided for in Article 267, Clause 1. Sorry, Clause 2. But it has some historical antecedents that we have to appreciate. Many years back, even on the question of ownership of minerals, until 1962, the state was not the owner of minerals. The Republic of Ghana took over minerals in 1962 with the passage of the Minerals Act of 1962. Because, you see, in 1962, the government passed a number of legislations. One, the Land Registry Act at 122. The Administration of Lands Act at 123. The Concessions Act at 125. Sorry, 4. The State Lands Act at 125. The law under which compulsory acquisitions were done. 125, State Land. Then the Minerals Act was 126, and the Survey Act was 127. The Minerals Act provision that took over the ownership of minerals was predicated on a finding of a committee which was set up by government at that time. And the committee came out with a report that the traditional authorities and the landowners who were granting mineral rights didn't know what they were doing and that they were being cheated. So the state should take over. I leave it to this distinguished gathering. Since the state took over in 1962, has the state done well in its own negotiations for those who exploit our minerals? Those chiefs were uneducated. I will forgive them. But us, because you have a mineral regime based on 25+% corporate tax and 3% royalty. So these foreigners, you tax 25% after declaration of profit, which they never declare because of transfer pricing and everything else that we have no control over. Why don't we have 15-20% royalty and corporate tax of 5% as our constitutional benchmark? I mean, you have to be tough. That this is our fundamental law. If you want to come and do business here, this is it. Because as for corporate tax, we will make nothing till their kingdom come. You are walking around IMF borrowing 3 billion over 3 years. And if you just change your royalty regime just to 15%, you wouldn't need any IMF or World Bank. You wouldn't need them. Everybody's fear is, if you do that, these guys will run away. Where? They want to go to Mali. So you, Ghana, the atmosphere you have created, you don't want to take advantage of it. They should go to DR Congo and invest there and see whether they can take their returns. So, that one. I was on the administrator of Students. This office has some historical antecedents when it comes to the state taking control over students, particularly the revenue. In 1958, before I was born, there was CPP and Matimehu. So the CPP government decided to take away the financial wherewithal of the Ashanti and Achimabwakwa schools. Not because of the interests of the state, no. Because these two schools allegedly were funding opposition political activities. So, the first of the legislations that was passed to take away student revenue was the Ashanti Student Revenue of 1958, number 28 of 1958. And then the Achimabwakwa Student Revenue, also of 1958, that one was number 78 of 1958, to take the revenues only from these two schools. Now, this system ultimately stopped, but metamorphosed into the Office of Administrator of Students in 267, which is created to establish a student account for each school and collect student revenue and disburse in accordance with a certain constitutional formula. I will tell you that the OASL is one of the organizations whose it's been scandal-free. You know, if you look at the scandals that have occurred around the Lands Commission, the OASL, and they've had a very interesting history. Since it was set up, only managed by women. All the heads have been women. And there have been no scandals. So, Mr. Chairman, we have to look at we, the males, again, whether there is some natural propensity to be scandalous, or maybe it's just accidental. But I am proposing that you should consider the possibility of bringing the OASL into the scheme of the Lands Commission. Because you see now, it is sitting as a stand-alone office. It has been seriously underfunded. For some reason, I don't know. It's been seriously underfunded. It has a good mandate. It's been seriously underfunded and virtually handicapped. It is not even resourced enough to collect enough revenue for its own costs. So if you know you create an organization that you won't fund, their personnel requirements are not met, then better take the OASL, put it in the Lands Commission as a division in the Lands Commission, which will be in charge of revenues, so that you can add the other revenues of the Lands Commission, the collection, to that mandate. Because you have a Lands Commission that has public investor lands, land valuation, survey and mapping, and land registration. So you can restructure OASL and make it the revenue wing division within the Lands Commission. And then they would also take responsibility for other revenues from non-stool lands, because if you look at Article 267, Clause 6, where it talks about the revenues, the disbursement, it says they would give 25% to the stool for its maintenance in keeping with its status. Question is, if the lands are Tindana lands, if the lands are Tindana lands, should the chief, and I'll give you a live example, Bolga. I did a case in the Supreme Court, Tindana Agongo Akubayela versus Ibrahim Awabigo in the Supreme Court, where the Tindanes won that in the Bolga areas, there are no stool lands, and that the customary custodians of those lands are the Tindanes. Now, if you look at Article 2676, the revenue from stool lands should go to the stool. If the Tindana is going to receive money, the Bolga Naba says, I am the stool. I am the skin. And so this is one of the areas that, as a team that is looking at reviewing this constitution, we should realize that we don't have a homogeneous body of customary law across this country. The framers operated on the assumption that all the lands were stool lands. If you go to Adan, there are no stool lands there. So if Nana Kwokun says he's collecting revenue because he has seen in Article 266 that revenues should be collected and paid to a stool. So if you push the administrator to the Lands Commission, some of these things can be avoided. Otherwise, fund the administrator to be able to collect the stool land revenues, because they are not being collected. And it is not because they don't want to collect. It is because they have no resources to be able to collect. They can collect a lot if you can give them the resources. Otherwise, take the administrator from, because they will be able to take advantage of the financial muscle of the Lands Commission. And they will be able to take advantage also of the possibilities that the Lands Commission would have more district offices as we go. Because even though the Lands Commission's Enabling Act says they can set up district offices, there's only one in Tema. One in Tema. 200 and something districts. Having said this, I think I'm coming to the end of my presentation, if it was a presentation at all. I think that there are critical issues that we have to address. And I think I said something about some of those critical issues. For example, if you look at Article 257, the clause 4, there's a certain history there. 257.4. And the history starts from 3. the divesting of the northern lands. For the avoidance of doubt, it is hereby declared that all the lands in the northern, upper east, and upper west regions of Ghana, which immediately before the coming into force of this constitution were vested in the government of Ghana, are no longer public lands within the meaning of Article 257. Now, in 1894 and 1896, when the Crown Lands Bills were introduced, the Aborigines Rights Protection Society fought to prevent the takeover of what they called at that time ownerless lands. Because, you know, the British felt uncultivated fallow lands were ownerless. So they were vesting those lands in the Crown. When the Aborigines Rights Protection Society fought those policies and succeeded, in 1901 and 1902, the Northern Territories Ordinance was enacted, which vested the lands in the then Northern Territories in the colonial government. So, for years, the Northern lands were vested in the colonial government, subsequently continued by the independent state. So, in the Tamale areas and elsewhere up north, lands were allocated by state entities. Then, by the time of the promulgation of the Constitution, there was intense lobbying by Northern intellectuals, particularly those who were based in Legon, that this was inequitable, that all the Northern lands are vested, but the Southern lands are not vested. Then, Article 3, automatically divested all the Northern lands without further assurance. And there are still pockets of problems associated with the divesting of the Northern lands. Because instead of a program, because some of those lands had been encumbered by state authorities, some of those lands, ownership was not established. So you plunged the lands back into chaos with the divesting without further assurance. And the aftermath is still there to be dealt with. They've not been dealt with. So you see, some of the confusion up north, which we clothe as chieftaincy problems, are not chieftaincy problems. They are land problems dressed as chieftaincy problems, because the chieftaincy denominator is the easiest one. So, if you go back and you are looking at Mampursi and Kusasi, and you think it's a chieftaincy problem, it's not. It's about who got to the land first, and who later became chief because somebody was a Tendana and someone came with chieftaincy, and they are fighting. It's the land. Because the control over the land is either through a Tindanaship or through chiefship. So we will fight. You can't just be a Tindana, but as for chiefship, you can create it. Because most of the chiefships up north were created by the colonials. The concept of Bolga Naba, for example, started from around 1941. So these things were not of time immemorial. So we should look at this whole regime again. Otherwise, we have other vested lands which have not been divested. And the Constitution didn't talk about those. The lands within 1 mile radius of the Winneba roundabout, the lands which is creating the problems between the Golden Stool and the Bonos. So Sunyani, Mem, Goso, Nkoko, Oforidua, the lands under Osumanche layout, the lands which were vested under EI 108 of 64, where GIJ and those areas, all these are vested lands, which potentially can create problems. The Land Act wanted to do something about this, but it couldn't. The last part I would say is there are some structural issues that you have to look at. One of the most important constitutional provisions that affect the land in this country is Article 20 of the Constitution, the power of eminent domain, the power of the state to compulsorily take private property. The interesting thing about Article 20 is that it just said property. It didn't say landed property. But generally, property could be movable or immovable. But the predominant use of Article 20 has been in relation to taking land. Now, Article 20 is inside Chapter 5 under human rights. Article 20 is inside Chapter 5 under human rights. We may consider taking Article 20 and beefing it up and bringing it into a specialized lands chapter. Instead of keeping it in the human rights part of the Constitution, it gets lost. You've taken it away from its the family, natural home. So we should find a way to bring Article 20 back. And Article 20 is only up to 7. Subsection, Article 20, clause 1, 2, 3, 4, 5, 6, and 7. If we lift it and we beef it up, giving our lessons relating to acquisitions and what is in the Land Act, we can rationalize it better. And then also, another structural thing that we may look at has to do with Article 36, clause 8. Article 36, clause 8. Article 36, clause 8 talks about the fiduciary obligations of the managers of land. Public, private, stool, skin, family, and that these are fiduciaries and should be held accountable as fiduciaries. Where it is hiding may not be good for the land sector. So let's take Article 36, clause 8. And if there is something we want to do to it, let's do it. And bring Article 36, clause 8 also home among land-related provisions. There is something cross-cutting. Article 36, clause 9. It's a very important provision that nobody talks about because, unfortunately, it's so-called, in the so-called transitional, what do you call it? Directive Principles of State Policy. 36.9. It talks about the obligations of the state to protect our national environment. Not to sound political, but anybody who watches or who has been watching this country in the last 20 years would know that apart from economic issues, the last election was virtually a referendum on the land sector. We may not like it, but I mean, when we university people, we are poor, but because of our academic freedom, we can say things. This whole election, if you waited, the land things would be about probably more than the economy. Because as for the economy, we all know there's no magic one to fix it. But we saw the destruction of the land in our naked eyes, by roadsides, by footpaths, by beaches, everywhere. And 36.9 says something about the environmental obligation of the Republic. We need to flag that provision and beef it up. Because from what we have seen, the biggest human right that we can get is our environmental rights. Unless there is no right to food, there's no right to life, there's no right to nothing if the environment is destroyed. So as we look at reviewing this constitution, we should find space for environmental protection as a national policy to be enshrined in our constitution. Because without that, we have no country. And we have seen it. We have seen it. Hard metals going into your water bodies and truncated berths and these, there are too many things that we have heard. So our environmental protection must be taken seriously. This is not something you can do in a day. I would make myself available at any time to come to continue this conversation. We need all of us. I was telling my learned senior that there is no important task than reviewing your constitution. If there is any more important task, because whether you pass or fail as a country, the fundamentals are here. Yes, the people factor is important, but this one is also very important. I thank you for the kind attention.
Thank you very, very much, Professor Kwame Jan. We've gotten our first baptism of fire. I think I speak for all of my colleagues on the committee when I say, if we had probably listened to you before we accepted the appointment, we would have asked for maybe a year to do this. But this is extremely enlightening, and we are happy that this is the opener for this session and for the entire stakeholder engagement. You've been more of a resource person than somebody who was just making a submission, and we're happy that you gave this very broad overview of where things stand, where the problems are. And we have about an hour for engaging you on the issue that you have raised. The timetable says we break at 11:45, but since 11:30, but since it is not break for lunch, I think we can move that to 11:45 and keep the break short for 15 minutes so that we can engage you on the issues you have raised. I'll first ask my colleagues, starting, whoever wants to start. I have my own questions, but I will reserve that for later. So go ahead, yes. See if it works.
Thank you very much. Thank you very much, Professor Kwame Jan, for that erudite presentation. He hardly fails. Thank you very much. I just want to take you back to Article 2664, which you spoke about, in relation to the leasehold situation to a non-Ghanaian. And as you rightly pointed out, there is no stipulation as to consequence of a breach. And just for context, let me just read that provision. It says that no interest in or right over any land in Ghana shall be created which vests in a person who is not a Ghanaian a leasehold for a term of more than 50 years at one time. And the consequence is not spelled out, as opposed to what we have in 2662, where there's a stipulation as to the consequence, which makes any such grant void. Now, from your experience, practice, and recommendation, would you say that we should create a similar pattern by saying that if you have a lease which exceeds 50 years at a go, should it be void or voidable? From your experience, what would you recommend?
2665 is in the same spirit as 2663. So, for the benefit of the audience, 2663 says, if on the 22nd day of August 1969, that is the date on which the 1969 Constitution became effective, if any person who is not or was not a citizen of Ghana held a freehold interest, it was reduced to a leasehold for 50 years, subject to peppercorn rent, and the reversion will be held by the president. So all these freeholds, and you know, there was a reason for this. Most of the prime lands in Accra and Kumasi were freeholds held by foreign companies and foreigners. Independence Avenue, all those areas were not in the hands of Gold Coasters and therefore Ghanaians. So what this provision did, and the areas around Tudu, all those areas were affected by 2663. So these freeholds were truncated into leases for 50 years, starting from the 22nd day of August. They have all expired. Only that the Lands Commission has not been able to trace those leases and properly register them in the name of the president, who is holding the reversion, so they can do fresh leases. Now, if you go to 266, the 5, it says if there was a subsisting lease for more than 50 years in favor of a non-citizen by the same 22nd day of August, it was truncated to 50 years. The attempt in creating a freehold has a very harsh sanction. And let me say, if I was drafting the Constitution, I would not place that sanction. I would rather reduce it to a lease for 50 years. Instead of nullifying, because maybe it was not as the result of mala fides, but someone's lawyer has not advised the person properly, and that whole transaction fails. So I would rather say that if you create a freehold for a foreigner, it should be truncated into a leasehold for 50 years. In the same vein, if you create a leasehold for 99 years for a foreigner, it should be truncated to a lease for 50 years. So you don't fail the transaction, because that consequence is too harsh.
So, Prof, in that case, in who would the reversion be vested? In the Republic or the grantor of the interest?
In the event of the leasehold, it should go to the grantor, because 266, the 5, if you look at the 3,
yes,
where it was talking about freeholds, the reversion is vested in the president. But in the 5, the leaseholds, it didn't say the reversion is vested in the president. It means that the drafter wanted to treat freeholds differently, so that the freehold reversion, because under normal circumstances, there is only a remote possibility that when you create a freehold, there will be a reversion. But for a leasehold, upon the fruition of time, the reversion kicks in. So I would keep the reversion of the leasehold for the grantor, the lessor.
Now, will you require that there should be refund of the monies collected as rent or lease for the lease at that point?
Refund
yes.
Between the grantor and the grantee.
Yes.
The state shouldn't go there.
So it should be left to personal
The state should just truncate and let the people deal with it at the level of contract. If somebody will come by way of an action for money had and received or failure of consideration, the state shouldn't get in. What the state has done is to reduce the term of years by the Constitution. That's it. As for what happened between the contractor and the lessor and the lessee, the state shouldn't get there. But I will reduce the harshness of 2662 and save the transaction, but at the level of a leasehold.
Chairman, if I have your permission, my last question to my prof. Prof, so what do you think we can do with our natural resources, minerals, to get the best out of them for this country?
What do you mean? What we can do to get the best out should start from being transparent about the resource itself. One, the transparency has different dimensions. The first dimension is transparency about where the resource actually is. There's lots of geological work that has been done in terms of mapping out what we have. The Republic should tell us. So now everybody is talking about lithium. On the quiet, a few people who are politically connected have taken the lithium. Since when did we know we had lithium? Long time ago. So the Republic has to learn how to be transparent with us as to what we have to start with. Then we should look again at the composition of the Minerals Commission. The Minerals Commission. We should look again at the composition of the Minerals Commission. We probably would have to set up one Natural Resource Commission. One Natural Resource Commission properly populated with the best brains and capacities we have. You know, I don't want to appear as elitist, but most of the problems we have had in resource management in this country, as well as in other aspects of our life, is when we have very competent people, but because those competent people, you know, very smart people appear to Ghanaians as arrogant. Really smart people who know what they are about, they appear as arrogant. Nobody will put you anywhere to do anything. So the people we put in particular positions to manage this resource, they are not good enough. And when they are not good enough, nothing comes out of it. In negotiations, we don't get the best. In exploitation, we don't. Do we all not know that there is always a government 10% retention in these mineral concessions? Who represents the government on the board of Newmont? Who represents the government on the board of Goldfields? With what capacity? What do they say when they go to board meetings? Apart from their sitting allowance and their fuel and their car boot, which is filled with provisions. What do they bring to the Republic? Nothing. So we need to set up, now people are setting up what? A gold board. I've heard that there is a gold board. So you set up a bauxite board, a manganese board, lithium board. Hey. Silica board, cobalt board. Where will you end with the boards? So I will establish an omnibus Ghana Natural Resource Commission and bring all these resources we have identified under the umbrella of that body. A proper body with representation and the caliber of people you bring there. It will be good for this country. But it is not this small board here, small board there, I mean, Minerals Commission. We should, look, this thing you are doing, do it well. If you make your nice propositions and politicians don't accept them, you'll be remembered as the people who made propositions which were groundbreaking and future forward-looking, but which were not accepted. That is better than to do a report to please politicians, and your great-grandchildren will see the report and see your names on it and say, ah, so my grandfather was the chair of this committee. You know, if there is anything I cherish, it's that I don't want to be associated with something that 10 years from now, people will trash. No. Come out with ideas. Bring the ideas to the stakeholders, all of us, to consider the ideas. If the Ghanaians approve and politicians reject, it's okay. Because, you know, it will be hard for you to push it through. Because everybody wants a turf to chop from. If you are not careful, you will have 20 boards, gold board, now you have gold, manganese, cobalt, salt. You have salt board, so potassium chloride, whatever, sodium chloride board. Because most of the time, we say things we know will not work because we don't want the things to work. Me alone, what can I say?
Sure.
think so.
What? Yeah.
Leonard Prof, who was my TA, and didn't teach me all these things. I have,
That time I wasn't his experience. I had just got to the back, and she was in second year at the University of Ghana, then Faculty of Law. I was telling her earlier, of all the things I've done, I've not received any award. And my students who go into politics after 2 years receive national award. For what, I don't know.
Prof, lucky for you, this student has not received either, so we're in the same place. Prof, I have 2 questions and a request. Still on Article 263 area, what should happen if, pursuant to the grant of a lease exceeding 50 years, the non-citizen acquires citizenship? I ask that because recently we've seen a flurry of grant of citizenship to non-citizens, and I've always wondered what the legal implications would be on other levels. Second question would be, I'm really happy that I think the issues you've raised really touch to the really serious issues that are impeding national growth, cohesion, and development. But we kind of missed out on the issue of the indigenes who own the lands in the capital. And there's been a lot of outrage from their side in terms of lands that were compulsorily acquired for the state for different purposes, the change of use, and how their property rights at family levels, individual levels have been affected. So how do we use the Constitution to manage this going forward? And my third issue is actually a request. I don't know of anybody who has more knowledge or experience than Prof in the area of lands and natural resource and all the issues that come up. I'm hoping he would volunteer to redraft the entire chapter 21 for the committee and save us the trouble. And I promise to be a good TA and support him. Thank you.
I take this, once you be my TA, we'll do the write-up. We'll do something. This will not be my last intervention. I will support this process. Now, going back to what my learned colleague has said, the drafters of the Constitution were not anticipating dual citizenship because the Constitution came before it was amended to make provision for dual nationality. So the easiest practical way for somebody in that situation is to go back now and do a deed of surrender and take a fresh grant. And the state will not come in, because you see, in these things you have to take out the republic. And it should not, your nationality should not automatically confer on you a freehold or a lease for more than 50 years. So if you have a lease for 50 years and you have become a Ghanaian citizen, which means you can take more than 50 years, go back to your grantor, your lessor, surrender the unexpired portion and take a fresh grant. Practically, this should be the way. Now, this whole question about land in the capital, I will tell you something. If I was in charge of managing the lands in Accra, this whole idea of government land and not government land and private person taking the land and not taking the land, we would have to look again at what the Supreme Court has done. Remember when I was saying, if you can be as clear as possible, don't give too much opportunity for interpretation. Look, there is Article 20, what I said we take into its proper home. There's Article 25 and 26 of the Constitution. 25 says, where land is taken for the public purpose or in the public interest, the land should be used for the stated public purpose or in the public interest. So you see how we lawyers, we draft and we open the holes. So the land which has been taken should be used for the stated public purpose or in the public interest. The biggest chunk of our issue has been in the public interest. Then 26 says, where land is taken for a stated public purpose or in the public interest, and it is not used for the stated public purpose or in the public interest, the pre-acquisition owners should be given a right of preemption. In other words, they have a right of first refusal to reacquire the land. You see, there is no right of re-entry. Like, okay, Republic of Ghana, you have not used the land for the purpose for which you took it. We have taken our land back. The Constitution doesn't make provision for that. They have to do a reacquisition and refund the whole or part of any compensation which has been paid to the Republic, according to the value at the time of the refund. So, cantonments. If you want your land back in cantonments because the purpose has failed, you have to be given the right of preemption to buy back your land, and you pay the value now according to what the Republic is going to assess. And that's the legal benchmark. Interestingly, there were two cases that went all the way. First one was a judgment of the Court of Appeal in Ni Olai Amontia versus Ghana Telecom. The lands of Ghana Telecom around Bubuyashi. And then there was the La Wireless case. Ni Potechuru, the third, versus Tete or Tete. Tete. Ni Pobi Tete Churu, the third, versus the Attorney General and Lands Commission, which is also known as the La Wireless case. In these two cases, our courts have said that Article 20, Clause 5 and 6 on reacquisitions do not apply to acquisitions that were done before 7 January 1993. So you see, if you look at the intendment of the drafters, what were they trying to do? They were trying to protect the existing acquisitions, particularly when the purpose of the acquisitions have failed. But the Supreme Court said, interpret prospective because of Article 107, which frowns on retroactivity. That is why I will not push my matters too much to the Supreme Court. I would rather write language which is clear and unambiguous so that it leaves no room for interpretation. So, Madam, what has happened to us is all the cases that were brought relating to the previous acquisitions, the Supreme Court said 25 and 6 will not apply. That they will apply only in respect of acquisitions after 7 January 1993. So there is no recourse. There is no recourse. Legally, there is no recourse. Maybe what the pre-acquisition owners have, if they have anything at all, was also taken out by the Supreme Court in the case of Memuna Mudi versus Entry, where the Supreme Court said the publication of an instrument of acquisition extinguishes all rights and interests that existed before the acquisition. So they get nothing left. I mean, you can spend the whole day on these matters. So they have nothing. In fact, if you want to interpret Memuna Mudi logically, they can't even mount an action in respect of those lands. Because where is the capacity? If you are being told that the acquisition extinguished everything that you had. So maybe what we have to do is, now that we have an opportunity, we probably may not, because you see, I also don't think your constitution should be too big. Whatever you can cover in legislation, take it out of the constitution and find a proper language in legislation to deal with. Instead of, because otherwise, if you are not careful, your constitution will be like that report. And if it is to set up a framework, then keep it at that. And let the details be supplied by legislation. But your problem is, you could do the framework, the legislation will not come. Because of Article 22. I'm done. The legislation will never come.
All right, thank you very much. And I think, Prof, your last point has almost taken the point I wanted to raise, which is that if we want to put as many things as possible in the Constitution, we would end up with something that's so huge and etc. And I'm saying this in relation specifically to the points you made about the lands in the north. I particularly like the point you made that we do not have this homogeneous system of traditional land management. And it looks like the assumption previously had been almost like everything is the same, and therefore we have overlooked some of this. And in relation to the points you made around Article 2574, I'm wondering, given the complexities, even of the North, is it possible to address those issues in the Constitution, or is that the Constitution may provide some very broad framework, and then subsequent, legislation policies would provide the granular details? Because it's so complex that if we, in these 6 months or 5 months of the Constitution, will not even have the time to talk with all the relevant stakeholders, particularly up north, and we might lose some perspectives. I remember it was around 1980, there was this Isifu Ali Commission on land tenure in the north. And right after that, you saw this huge upsurge of conflicts, because again, the assumption was that all the ethnic groups in the north had the same, structures, and lands were being vested in chiefs and etc. And that led to very violent conflicts and etc. So I think this whole thing about dealing with the land situation in the north is complex, it's urgent, but I think it needs some time, and therefore I wonder what advice you give in terms of how we frame it in the Constitution, but that allows the flexibility and the room for consultations that would result in legislation or policies that address specifics. Thank you.
Maybe before you respond, I think in the interest of time, let's take a couple more questions, and then you can respond.
Thank you so much, Prof. And I was also privileged to be taught by Professor Jan as a substantive land law lecturer, 2005, and we've met again. Now, this intervention is to add to the point that Mr. Tanko is making in terms of the North. Now, I have also been practicing land law in Bolkatanga areas, and I take cognizance of the Supreme Court ruling regarding Tindana. But there's some information I would want us to look at and see what your insights would be. And I tie that into what would be the solution overall. Now, in the past 10 or so years, because Bolga is becoming cosmopolitan and the land supply system, because it's a very small region as well, so the land supply system doesn't meet development needs. There's been some contestations. One of it is between the chiefs and the Tindanes. Now, the chiefs, because the chiefs want to mimic what happens in a southern sector, because there's the understanding of a chief and his tool and the power that he wields is not quite the same as in the north, when in relation to land ownership. Now, precisely, even though the Tindana has jurisdiction over lands in the north, and here I'm speaking also as an indigent, that ownership is jurisdictional. It is not proprietary. And we need to make that distinction. There is a clear distinction between jurisdictional ownership of land and then proprietary ownership. Now, the jurisdictional ownership that the Tindanes have allow them to supervise certain matters concerning land, certain rights, libations. If you're a family, you need to go to the farm during the farming season, you need clearance from the Tindana. If there are disputes over the land, the Tindanas will have to preside. But that has nothing to do with the proprietary ownership in terms of leasing or even being a signatory. The lands predominantly remain the ownership of families. And each family together, a number of families, constitute a Tindanaship. So that's the arrangement. So you have a Tindana so this is how it is. You may have 2 or 3 Tindanas within a chieftaincy. But if each Tindana has a number of families and the proprietary use of that land belongs to the families, whereas the jurisdictional ownership, like I've explained earlier, belongs to the Tindana. So in terms of stool land, the concept of stool land and the collection of rent and how they distribute this, I will need your insights as to that, because that's problematic. As I speak now, I also have cases in Bolka where there are even issues as to who is the legitimate person to sign the lease. Now, you look at the Tongo areas, there are now mining activities that are coming up in recent times. And I foresee that there was some conflict because it is brewing. Because the chiefs want to deal with the investors who are in the region of Bolgatanga, the Cardinal Manning area. This is a present issue. So they have all the motivation to sign those leases. But the land do not belong to the chiefs. The chiefs are not, they also have, so now you have lands that are proprietary owned by the families. You have the Tindanas that have some jurisdiction in terms of spiritual and other adjudicating authority. And you have a third layer, which is the chieftaincy institution, which is not well understood and is not aligned with the cultural understanding of the North. So this is the complexity that is presented in terms of the North. And we need to have this understanding so that when we're proffering solutions, we can have a proper way forward. Thank you. So I wanted to ask, I have two other issues.
We don't have a lot of time.
Yes, you do. Yes.
The chairman hasn't asked this question. Maybe we'll let Professor Jan, we will have further interactions with him, so he's offered to assist the committee beyond this interaction. So I think.
So, Prof, once again, thank you for your presentation. It was really wonderful. Do I get the feeling from where I sit, there were three main themes that underpinned your entire presentation?
Would you please kindly introduce yourself so that we can record?
Okay. I'm Anua Ama. I'm a member of the Gandangwe Council, and I'm in charge of cultural heritage. I'm also the head of family of Tema Ashiwe Bonoweku, but I'm not here on the basis of that. I'm here on the basis of the Gandangwe Council. So the three issues I picked from your presentation, really ownership, benefit sharing, and resource management. You seem to have said some few things about the opportunities this present to us. What about challenges in your view? Will they pose any challenges to us? And what are your comments on the way forward, taking into consideration the benefits, the challenges? Thank you.
Thank you very much. We have all come from the Gandangwe Council, and we are interested in Article 25 and 6. I agree with my learned friend that the Supreme Court has not helped us at all in the interpretations they have put on that matter. But in our write-up to you, we looked at the review of the Nipo Bitetechu decision, where Sofa Akufu Atuguba and Sofa Adinyra seriously held the view that they think they were wrong in what they said. And so, knowing that she is on the committee, I have pushed that point and quoted her extensively that we need to do something. No, knowing that she is on the minority. Yes. The vigorous dissenting view, you know. So we are calling on the Commission to look at it from the view of the minority in that position. But the more difficult one is this public interest thing. Because even if you allow it, you know, to apply to lands taken before the Constitution came into force, will still be met with this so-called public interest. So we have been looking at a situation where on the face of the EI, which takes or acquires the land, you state the purpose. State the purpose in black and white. And don't come and tell us about public interest or any other matter. You said you wanted the land for A. You are not using it for A. Give it back to the owners. And this whole idea of repurchasing the land at the value at the time that you're asking is with the greatest respect. It doesn't make sense. You take my land in 1960, and then 2010 or 2020, you tell me I should pay the value before I can take it back. Meanwhile, when you took it, you deprived me of the use of that land. Compensation, small compensation in those days, yes. But a lot of them, they have not even paid the compensation. A lot of them, the compensations have not been paid. So we are here more on this 25 and 26 as to how to make it applicable, taking our inspiration from the vigorous dissenting judgments of the three individuals. Anyway, let's keep on. This idea that I was thinking of this surrender thing, I wanted to say that, this constitution is also a law which is applicable, only that it is the fundamental law. So it is being applied. All these sections on 266 and the rest. And the clever people are always giving back, surrendering, and getting new leases. If the thing is about to, expire, surrender, get a new one, and then they are in good shape. As for the leases, if you went and sold freehold, what it meant is that you didn't want it anymore, so it's gone. It is government which is saying that I've given it for 50 years, so let the reversion come to the president. I understand that one. So with the lease, you know that by all means, that one will come back. Mm-hmm. So that those who gave up those lands before the constitution came into force are only calculating the 50 years. At the end of the day, they come and tell you, give me back my land. That is what is happening. It's unfortunate that some of these things we are having a lot of difficulties. Thank you.
Okay, thank you, Mr. Honorable Aiko, to former AG. So I don't know if I should save my question for another time because we're running out of time very quickly. We have 11, it's about 11:30, I said 11:45. But maybe you can just, you don't have to answer the questions that I will put on your plate yet. You have made mention, and I don't know if it's a Freudian slip, but whenever you wanted to say vest in the president, which is the language of the Constitution, you kept saying it vests in the republic. Actually, that would have been my preference because I'm not particularly comfortable with vesting everything in the president. But you kept saying vesting in the republic, and I said, well, maybe that's what he prefers in terms of formulation, or maybe in some countries it's vesting in the government on behalf and in trust for the people. So that's one question, this vesting in the president, which is not further elaborated in the Constitution in terms of what obligations flow out of that trusteeship status, right, of the president. A trustee, like other fiduciaries, should have certain obligations towards the trust beneficiaries. Our president, as the one in whom these assets, whether it's public lands or minerals, are vested, appears not to have any obligations at all or responsibilities as trustee to the people, to parliament, or to anybody at all. So that's one of the issues that I would like you to reflect on for us, because especially when it goes to these issues of resource management and benefit sharing. Then second, I find it intriguing that you propose that, after admitting that the Office of Administrator of Two Lands has been relatively scandal-free over the years, and that the Lands Commission has been more the scandal-prone entity, you want to fold a scandal-free entity into one that has been historically more scandal-prone and contaminate the scandal-free one. So are there no other ways we could do that? But I think the more substantive question is the model, the structure we use for the Lands Commission. It's the only one in the Constitution that is very detailed out in terms of the commissions that the Constitution anticipates would be established. Do you find anything problematic about that structure, its composition, the way it goes about its work? And what can we do about it? Because there's a lot of scandal in the public land sector, in the vested lands area. And so the Lands Commission sits on top of this problem. And how do we deal with it, especially to prevent us using it as a model to set up the other ones? Because it's the only one that is fully elaborated in the Constitution. It has this tendency of being used as a model to do all the other natural resource ones. How would you restructure it, if at all, so that it serves our purposes and minimizes the problems that we have with these bodies? I like very much your idea of relocating all the land-related provisions scattered elsewhere and putting them in the chapter on lands and natural resources. But my main interest here has been actually the resource governance problem that we have and the ensuing problems that have arisen, most contemporary problem being the Galamsey issue. And I think I have no doubt from your comments that you do have some clear restructuring ideas in terms of how we do the benefit sharing, how we do the governance, so that we tackle these big problems that we're facing. You don't have to answer immediately, but I think I would like to get your insights on that at some point. Yeah. So basically, I think Justice Adinri has gone to the heart of the matter, which is that if you are a trustee, right? If you are the trustee, at the very minimum, we must have certain obligations placed on your plate, including, as she would have us do, having the president on a periodic basis report to Parliament, that being the People's Assembly, on how this resource is being managed, how all of these resources are being managed, what is, in all of those things, right? How are you using the trust powers? I mean, we are the trust beneficiaries. You are just a trustee, but we can't come to you for an accounting. You don't account to us. You don't do anything at all. And I think that you are onto something when you keep saying investing in the Republic, because you don't want it to be in the president's hand. I don't want that either. But if we could at least elaborate some obligations. Yes, like State of the Union, exactly. So I think we are quite like-minded. We like where you are taking us in terms of trying to elaborate more accountability regime, more transparency around these things, but maybe something more specific. If you could propose some of these remedies.
I'll give you some more information. But now, my use of vested in the Republic, I don't believe in everything vested in the president. The Article 2576 itself sets that pace. That every mineral in its natural state, under, is the property of the Republic. And it says, it shall be vested in the present president only on behalf of and in trust for the people of Ghana. So the reason they added that leg was to confirm that the mineral wealth of the country is not for those people who live where the minerals are only. It's for all of us. Otherwise, they would have said the president holds it in trust for the people of the place where the land is. Because if you look at Section 7 of the Administration of Lands Act, where it's been repealed, but where it talks about the power of the president to vest land in himself, it says that he holds it in trust for the people who were the owners of the land. But when it comes to minerals, he holds in trust for all of us at the same time. So I think that as we go forward, we should minimize the references to the president, because it becomes, most people are complaining that the president is too powerful. These are the words and phrases which are fueling those things. But you remember earlier I said we don't have transparency in the sector. We don't even know how much we got from our minerals. We don't know specifically how much of it was spent. There's something they call MIF, Minerals Income Investment Fund. I mean, those of you who have been following recently, big millions. And you'll be surprised. The people who are managing the MIF probably don't even know how minerals are mined. But they sit there because they are political appointees. And they decide on what happens to the mineral wealth of this country. So I think this is something that we really have to look at again. You remember I was saying we probably have to look at an omnibus natural resource board, properly populated with capacity. Maybe that's something we should look at. Now, my senior was talking about public interest. It is one of the difficulties we have in the Constitution. And I'll give you an example. If you go to any serious country, airports have certain accompanying infrastructure, hotels, shops, malls, not so. So if land is taken, let me take you to Legon. The University College of the Gold Coast acquisition was 1948. And it was specifically stated that it was for purposes of setting up a university. But most of the colonial acquisitions, the instruments say that the lands have been taken for the services of the colony. Those are the areas where the danger is coming from. Where it is not a specific purpose. Marine Drive. Those lands were taken originally under the Public Lands Leasehold Ordinance of 1876 for the purposes of the services of the colony. So, if the land use is changed, how are you going to attack that use? Because unless you are saying that it is no longer for the purposes of the colony. And then, going back to Legon, you have 50,000 students and faculty and staff on the campus. Do they have to have shopping malls around them? Gas filling stations, lorry stations, eateries, restaurants? Not so. Is the university land appropriate candidate for that? Is it use which is reasonably incidental to the original purpose of the acquisition? So when you get to this, so airport city, shops, hotels, is this use too different? But then look at aviation land and Ghana at 50, AU Village. Is this use not too far away? So we need to use some benchmarks. Maybe not in the Constitution, but some statutory benchmarks for dealing with this. Because somebody was telling me not long ago, if government has land to put on the market, why isn't those lands being auctioned? And you know what somebody told me about the Supreme Court? I know that my ladyship is not a beneficiary. There was this perception that the Supreme Court judges historically have also benefited from government land. So that the interpretation in 2.5 of 25 and 6 was expected. So we should, all of us as a country, Look at some of these things again. And let me also say this. If someone graduates from law school, works as a magistrate, as a high court judge, as a court of appeal judge, as a Supreme Court judge, all her life for 50 years, and comes on retirement, and he's given one government plot in cantonments. I mean, what is so something about it? That person's contribution to the republic. Is it possible for us to find a way of rewarding that person's service versus somebody who has worked all their life in the private sector, who has made a lot of money, and or somebody who has not done anything in their lives, he becomes a politician. Then the next day he has land in cantonments. So we should have some parameters. How do we value these lands? Is land in cantonments a matter for $60,000 or 60,000 cedis? So these things, and you cannot do this in the Constitution. What you have to do is to state the new national policy in the Constitution and leave the granules, like our brother said, to be filled in a legislation. And maybe for all those areas where you are going to prefer the passage of new laws, time it. Don't do the Article 22. Do the Article 269 thing. In Article 269, when they were talking about the Natural Resource Commissions, they were given 6 months. And in fact, in the 6 months they did, except that there were mistakes, particularly with the Forestry Commission Act. So not long thereafter, they passed a new legislation, but at least they did it. If you leave it for people at their discretion, you will never get those legislations you need to be able to give teeth to whatever you are going to put in the Constitution. And on the northern lands, you raise a very critical question about the relationship between proprietary interest and jurisdictional control. And the Supreme Court in Awabigo said, where the land is vacant, undeveloped, has never been touched, if government was acquiring, 100% of the compensation should go to the Tindana. Where a family is on the land, the families, this case was between the Aure family of Calbion and the Tindana of Tindon Sobligo. But all the other Tindanas joined, because in Bolga there are 4 Tindanas. The Tindana of Soin, the Tindana of Daporitindongo, the Tindana of Tindomolgo, and the Tindon Sobligo Tindana. And they joined, and I was their lawyer. And the court said, if the land has not been cultivated at all, virgin land, Tindana has the allodial. If the land has been cultivated, the Tindana still has the allodial. But the families that are on the land, they already had agreed on a 40-60 sharing formula with the Tindanas. So the Supreme Court said, we are holding you to your formula. So this was the Supreme Court's way, and that is why I am not in a position to agree with you when you say that the Tindana has only jurisdictional rights. Because the Tindana has more than jurisdictional rights. Because in the Gurini language, Tingadana, exactly. So it's not as simple as that. So I think that unless the chairman has some other more questions, we will continue.
All those who have gotten free legal advice, please pay the fee to the committee, and then we will we have a sharing arrangement with Professor
We will continue.
Professor
We will
Kwame
still
Jan.
continue.
But I think we can maybe during the break you can have a side chat with Professor Kwame Jan if he's staying also for the rest of the or for the second presentation. He's most welcome to do so. I think we can all benefit from his participation in the rest of today's meetings. But I know he's a busy man. And if he would like to take leave, we would permit him. But I think we really would like the meeting to remain for the duration, and so you are very welcome to stay after the break. Thank you. So we'll have a 15-minute break, and then we come back here. Thank you. for setting the tone, not just for today's, but I think he set the tone for all of the stakeholder engagements that we're going to have. It was very clear. On the committee, we decided very early on that we would be approaching this from a problem-solving perspective. So we're looking to identify what the problems are, whether the problems emanate from the Constitution or not, what are the problems, and if we can solve them through the Constitution review process, then we would take them on board as part of our remit. And if the problems also emanate from the Constitution, we would like to know what the problems are from the perspective of the stakeholders. So this was a very, very good introduction, an excellent introduction to our work. And we want to carry on in that same vein, in that same spirit. So we know that there are other stakeholders here. We did not do, we did not introduce everybody this morning. We just introduced ourselves on the committee. So I think we will start from the far end there. If you can mention your name and the institution or organization or the capacity, if it's personal, your capacity, and then if you are interested in making a presentation, if you've already submitted and you want to do an oral engagement, that's fine. If you haven't made a written submission and you still want to engage, we will give the privilege first to those who have made a written submission and want to do an oral follow-up, and then we'll come back to you. Thank you.
All right. Thank you very much. I am Lawson Bosokin. I work at the Lands Commission as a land administration officer. I'm here in my personal capacity. I made some inputs to the committee, and I'm here to make the oral presentation for them. Thank you.
All right, thank you very much. My name is Geoffrey Osafo, Director for Land Administration at the Office of the Administrator of Stool Lands. We made a presentation to the committee, and we are here to defend it. Thank you.
Thank you very much. My name is Sovia Ebenezer Atta. I'm also with the Office of the Administrator of Stool Lands as the Director for Policy and Planning. And we are here to defend our presentation to the committee. Thank you.
Good afternoon. Surveyor Clarence Bosompim Coleman, also with the Office of Administrator of Stool Lands, Director in charge of Research and Statistics. Thank you.
Thank you, Mr. Chairman. I'm Dixon Agbogang. I'm also with the Office of the Administrator of Stool Lands. I'm a lawyer by profession. Thank you.
Thanks.
Thank you very much, Chair. Anua Ama is my name, Gadangme Council in charge of heritage. Thank you.
Thank you, Mr. Chair. My name is Ning Teiko Kome. I am from Gandangwe Council.
Ayuku Utu is my name. I'm the president of the Gandangwe Council. And we've also made a submission.
My name is Kweku Entry Boesiako. I'm with the Secretariat for the committee. Thank you.
Enrico Usumensa, former Deputy Clerk of Parliament. I'm with the Secretariat.
Thank you. My name is Reina Akumperigia. I'm the Secretary to the Constitutional Review Committee.
Good morning, everyone. My name is Gad Asowe Akwensivia. I'm the Acting Administrator of Stool Lands.
My name is Aretha Bamford, trainee and legal research assistant.
My name is Kwesi Mpoja. I'm also a legal research assistant.
Three presentations, one institutional or organizational, that's two. So the Office of Administrator of Stuland, then the Gadangbe Council, and then the lands officer, but in his personal capacity. I think we will take your presentations in that order. Let's start with the Office of Administrator of Stulands, and then we go to the Gadangbe Council, and then we'll come to the individual presentation next.
Chair, thank you very much for this opportunity. The office is indeed very grateful for getting us here to make our input. On behalf of the office, Director Policy Planning, the person of Mr. Arthur, will do our submission. Thank you.
Thank you very much, Acting Administrator, for giving me the opportunity. Mr. Prof. Chairman and honorable members of the committee and ladies and gentlemen, on behalf of the Administrator of Stulands, we would like to give highlights of our presentation that we've made to the committee. I think it's about 5-page, report that we sent to the committee. But for the purpose of our engagement today, I'll just try to summarize it and give the highlights of what we presented. As an office, our mandate stems from the 1992 Constitution. Even though the 1969 and 79 constitutions mentioned that there shall be an office of the Administrator of Stulands, it was never created in the form that we have now. It was after the 1992 Constitution that the Office of the Administrator of Stulands Act at 481 in 1994 came into being. And the first Administrator of Stulands was appointed in October 1996. So next year, the office will be 30 years now. And Article 267 of the 1992 Constitution states that all Stuland in Ghana shall vest in the appropriate stool on behalf of and in trust for the subjects of the stool in accordance with customary law and usage. And by the discussions herein, we were talking before my presentation about vesting and all other issues. So now we know that stool lands vest in the stool, but the beneficiaries are the people. So from that, the Constitution further said there shall be established the Office of the Administrator of Stool Lands to be responsible for establishment of stool lands accounts, collection of stool land revenue, and disbursement. This is the core function. We also do other things, which is educating chiefs, consulting them, providing a framework for policy direction with stool lands. We do that in consultation with Lands Commission. And we also coordinate, the policy framework and all other issues. We've done this for the past almost 30 years, and we've realized that there are some challenges that are affecting the full implementation of the vision of the framers of the Constitution. One of the key challenges we faced was that prior to the establishment of the office, stool lands was defined to include all other stool lands, family lands, clan lands, Tindana lands, and all other lands. So for that matter, as we speak now, we even have lands, family lands that we manage. We collect rents for a lot of families in Accra, in Western region, and so on, because that was what was originally done. But the Constitution under Article 2951, the definition of stool lands, we realize that the word family was left out, even though the definition said it includes, which can be expanded to include that. But because it was left out, there was a challenge at the Supreme Court and then, no, at the courts. And I think the conclusion was that family lands are not part of stool lands, properly so called. So we've made a petition to this committee that we need to look at Article 295 and expand the scope of what stool lands means. Because this has been the narration all along. 1969 Constitution defines stool lands to include family lands, clan lands, everything. In fact, Olenu, Justice Olenu, in his book, The Basic Principles of Customary Land Law in Ghana, 1962, page 9, he opined that stool or skin in which that ownership is vested may be a paramount stool, a paramount skin in the constitutional sense. Example, Chimebuakwa, Kowu, Wasa, Kotoku, and so on and so forth. Example, the divisional stool of Ghana states Bese, Asen, Osu, La, stools of Equapim state. Example, Manfi Latte. It may be tribal or family lands. Example, tribal or family stools in the Anglon areas and in some Fanti areas such as Ejumakun. So the narration of stool lands has always been defined to include family lands. And it has become more important to us because we see our role in benefit sharing in the light of equity, fairness, and development. Because 55% of the revenue that we mobilize is supposed to go to the district assemblies for development. Now, if you have two sets of lands, even adjoining, and one land is stool, and the other land is family, what it means is that by the mandates we have now, it's very difficult to collect from the family unless we have an MOU with them. It's not automatic. And the family land will not be contributing to development in the area, but the stool land will be contributing to development in the area. And it's the same area. In fact, the Constitution, as we have now, defines the stool land to include community lands. But one may ask, what is even community lands? It's a big stool like Bawe. Isn't it a community? But we are being told it's a family land, so our mandate cannot extend to that point. It is for this reason that as an office, we think if the Article 295, the definition of stool lands, is expanded to include clan lands and family lands specifically, then our mandate as an office to collect stool land revenue and disperse it for all the beneficiaries, which is stool, traditional council, and then our district assembly, we can apply that. Of course, it will mean that looking at a formula for disbursement of family and clan lands, because they do not fall directly under the traditional council, then it means that we should have a formula. They could benefit 45%, whilst the assembly gets 55%, if we are able to, change the Constitution to reflect this. That is not the only point that we presented. We're also of the view that some of the articles, 259, 261, which sort of gave birth to the commission and then the members, can be expanded to include the administrator of stool lands and regional officers of the Administrator of Stool Lands, because we have the Regional Lands Commission, that is Article 261. We have the National Lands Commission, Article 259. And in that, the Administrator of Stool Lands, who in the same constitution has been mandated to work closely with Lands Commission to prepare a policy framework for rational development of stool lands and other lands, has been left out of the commission, where these decisions in terms of policy are supposed to take place. So for us, we think it's important we amend these sessions to include the office of the Administrator of Stool Lands. The other point that I want to talk about is the fact that even though we are lacking in terms of working with family lands, we've always been known as the customary land sector by the Ministry of Lands and Natural Resources, because in the government budgeting and framework, there's the need for the ministry to tackle all aspects of customary lands, because ministries are worked in such a way that they should have an arm over every aspect of development in the country. So even though we are given that recognition, the law or the constitution does not permit us to go too deep into family land affairs. So we are even advocating that if the constitution is changed and the definition is changed, our law could be changed to the office of the Administrator of Customary Lands instead of stool lands, which will limit our scope. But then we can look at the full spectrum of customary land administration. We do a lot of services, like even ADR, where stools are brought and issues affecting them, we resolve them. There are a lot of cases but we cannot do that much for other customary lands, like the clan, the family lands, the usufructuary, interest, and all these various types of land that Professor Jan alluded to. So without boring us, these are the main highlights, but I believe we'll have time to talk about. My colleague wants to add something small to it so that we can make a headway forward. Thank you very much.
Chair, with your permission. Thank you. We've realized as an office that over the years, in especially urban areas where land values have shot up, stool lands are fast disintegrating into family lands. And then in areas that in time past we knew to be stool lands have now become family lands. And as my brother said, when you move from stool lands to family land, the incidence of sharing of benefits to the land becomes extinguished, and the money only remains with the family. So, for instance, if where we had our coffee break is a family land area, they will not be contributing any money to the development of the district. But if this room is a stool land area, the stool land people are called upon to contribute. We are of the opinion that if it becomes customary land administration, then everyone will contribute his or her fair share to the development of Mother Ghana. And, again, there has been a lot of disputes among the families and then the stools. Because as you break away from the stool, you are also extinguishing the interest of the unborn generation, which, if I'm right, I think Ofriata made us aware that land belongs to the dead, the living, and then the unborn. Family lands can give whatever interest they so seek to give, but stool land you are somewhat prevented. So that is another area we can call upon the commission to look at, so that at the end of the day, when it comes to land administration generally, there will be fairness. Yes, there will be the differences, as our brother pointed out, in the north. In fact, our regional officer for the Upper East region keeps telling us that if we don't take care, sooner than later, almost all the lands in the Upper East region, there will be statutory declaration to change the ownership structure. So we can look at it that way, and then the very details, we can look at law to address those issues. I think I've presented all.
Thank you. Thank you very much. That's very, very helpful, especially following Professor John's presentation. This gives us additional insight into one other entity in the land area about which I must confess I knew very little until your presentation has clarified a few things for me. Anybody with a question?
Mr. Chair, a small input or addition. Additionally, as a country, it is estimated that 80% of our lands are under customary ownership. 80%. But there has not been any major government intervention in that direction. Indeed, we carried out what we call the land administration project over the years. It was more skewed towards the Lands Commission and its operations. We, as an office, we established what we call customary land secretariats across the country. We led that process under the land administration project. So we go beyond revenue generation to land administration, actually, at the bringing should I say, land administration to the doorstep of people. We are the most decentralized office. We have over 200 district offices as we speak. Lastly, I think there's been a ruling, a High Court ruling, I'm not a lawyer, so, that Tindana lands were stew lands because they are communally owned. Communally owned. But we have not been able to, as it were, actualize it. These are some of the challenges. Because if you look at what the definition of stew land states in the Constitution, it talks about the land or interest that belongs to the captain of a company, the head of a community. As to who are the lands that belong to the captain of a company as a country, we don't know. Thank you very much.
Thank you. Let me just ask a few questions. I think, so I think it's helpful that you are recommending a name change along with your proposals, because sometimes you can be a victim of your name. If you are the Office of Administrator of Stew Land and you start, wanting to take skin land and family land under your jurisdiction, you are likely to face some opposition, and the name doesn't quite help. I would like to get some clarification on just your office first. When you say, so you have an administrator, the Office of Stew Land Administration, Office of Stew Land Administrator.
Office of the Administrator of Stew Lands.
So you do have, the head is the administrator.
Yes.
Is that the sole decision maker, or how does the stew land work in terms of decision making? Do we have, it's not a commission, it's not a collegial body like our committee. You have one administrator who has an office. Is that my understanding?
Yes, that is what it is. But as an office, we've developed procedures. In fact, the Constitution also talks about the regional stew lands officers who do the work of the administrator in the region concerned.
That's right.
So we have regional stew lands officers who also manage those lands at the regional level and disperse the revenue.
But it's basically a one head.
Yes, a one head. But
Okay.
then we have a management that takes the decision at the head office. So, but we don't have a board.
That's right.
Yes.
You don't have a commission.
We don't have a board. Yes.
Okay.
Thank you.
Now, under Article 36.8, you consider your office as subject to 36.8's fiduciary obligations, right?
Exactly.
So you are managers because you do manage the land. So you are okay. Now, I think I understand your benefit sharing function, which is very helpful. So what you are doing is collecting revenues that accrue to particular communal lands, and then you are sharing them for the benefit of local development. So you are giving it to the districts where the revenues are generated. But you do also, you send some up to the central government, or everything stays? You use some for your office to manage your office, your internally generated funds, 10%, and then you are supposed to give some to the various local functionaries, the stool, the local administration, the local government unit and the like. You don't take anything up to the central government.
No, let me explain the disbursement. It says that all the money that we mobilize, the office is supposed to keep 10% for administrative expenses. Now the remainder is converted to 100%.
That's right.
We give 25% to the stools from whom the monies were mobilized, and then 20% to the district, the traditional authority where that stool belongs to. Stools are categorized into traditional councils, house of chiefs, and so on. And then we give 55% to the assembly within the area where the stool land is located. So by giving that 55%, it's like helping government in development. So nothing goes to consolidated fund or central government. Thank you.
So a number of questions, a number of issues have come up on this disbursement formula that I'm aware of. So there are those, one question is, just as Professor Jan said in relation to the president or the republic, have you ever seen the republic? Nobody has quite ever seen the stool. We know the chief, we know the Omahine. But when it comes to stool lands, it's interesting that they don't make the chief the trustee, but they make the stool, and nobody has quite seen the stool. So there are, of course, debates around what they do with the money, right? What the upkeep of the stool or whatever means. But your job terminates the moment you hand over the money to the stool. Who do you give the money to? The Omahine? Who do you give the money to when you say the stool?
In the case of the stool, the occupant of the stool, who may be the chief or the secretary who he will elect, will normally come with a letter to apply for the funds standing to the credit of that stool's account. And
how they use it, you don't have anything to do with
Yes,
that.
the Constitution says it's for the maintenance of the stool in keeping with their form. So we don't go there, their status, we don't go there after we've paid those monies.
Right. And then the traditional authority also, then you go to the next layer.
Yes.
After the stool, you give
After
money.
the stool, the traditional authority takes 20%. And that traditional authority, in most cases, are the traditional council within that area. So if, let's say, we take Joabin, traditional council, for instance, it's made up of other stools like Konongo stool, Odumasi stool, others. So if the stool gets his portion, the Joabin traditional council, headed by the paramount chief, will also get the 20% out of the stool's portion.
For a use that you don't control.
For a use that we don't control. That the Constitution doesn't talk about.
Doesn't specify at all. Okay, so that's 45% gone to stool and traditional authority for uses you don't control. And then 55 then goes to the district assembly, of course, for the local administration. Now, the point Professor Jan made was about your organization or institution was that you are, as currently set up or resourced, you are unable to do your job effectively even as to stool lands. And now you want family lands, right, to be added. So is there no other way of capturing, if people are opportunistically taking land away from stool land and reclassifying them as family land to escape your jurisdiction, are there no other ways of capturing the revenues that come from family lands? Is a tax possible? Can we put a particular tax on family lands so that we can capture some revenues there? Or how are you resolving this problem of you don't have capacity to be effective to cover all the stool lands, and yet you want family lands to be added to your job?
Thank you, Prof. Chairman. As for the capacity, we have overcapacity. We disagree with Prof. Jan on the fact that we cannot do our job well. I think he also alluded to the fact that we are scandal-free and we are professional, and if our scope is extended, we can perform. You know, the 10% goes to do so many things. Our travels, districts, and all that, our human resource capacity. But because our scope has not been extended, and it's only with the stool and it's not expanded, some who are even paying are also questioning, why am I paying? And this family land that is also adjacent are not paying, and those things. Those are the challenges. In fact, as we speak now, we've signed MOU with a lot of families that we collect for them. And it's because they see our capacity to be able to mobilize revenues effectively. Even with Lands Commission, some of the areas we manage, we collect funds from vested land for them. In Sunyani, for instance, Stu Lands is collecting vested land revenue. Even though Lands Commission is supposed to manage vested land, give the revenues to Stu Lands to disburse, because vested land are being managed on behalf of the beneficiaries. So we collect vested revenue from Lands Commission and disburse to the Stus. But in some of the cases, they've ceded even the collection of some of the vested lands to us. And then we have a formula that we share the 10%. It goes to tell you that we've developed our unique skills and capacity in managing revenues coming out of Stu lands.
And Prof, if I may give a 7-year revenue trend for you to see, respectfully. From 2018, the office collected at least 57 million, around almost 60 million. In Ghana cedis. Yes, please. In 2019, 81. 2020 went to 97 million, as I'm saying. 2021, 106. 2022, we did 512. 125, sorry, 125. And then in 2023, 150. 2024, we did 211 million. So you can see that the revenue trend.
If you're operating at full capacity, if you look at the coverage, if you look at, say, the whole portfolio of Stu lands that you could actually reach, and if you valued it and if you did all of that, what would be your capacity? If you were operating at 100% capacity, how much could you raise?
Yeah. Because there's a challenge there, because it's not the entire country that there's Stu lands. So we are not able to, as of now, collect in areas that are not declared as Stu land areas. So all those portions are taken out from us.
So even based on the point that Alaji and Professor Jan made, that we have this asymmetrical, system in the country where not every place has a Stu land. Do you include skin lands under your jurisdiction?
Yes, please. Skin land definition.
Skin lands, Stu lands, and all of that. Roughly how much could you collect? Hello?
My colleague says we can do $1 billion.
Okay. No, I mean, I think it's an interesting. So the only land that theoretically legally escapes your jurisdiction is completely private land, like personal land.
No, not for now. When you declare your land as a family land, because of a high court ruling.
No, I'm saying that, assuming that we accepted your proposal, that you want all customary land or all communal land or all community land to fall under your jurisdiction, then the only land in any local area that you wouldn't have control over is my personal land, if there's any such thing, right?
Exactly. So the personal land, we have two categories. If you have a lease from a Stu or a family, now the land at prohibits even the grant of a freehold on lands. So in that case, the office will come to you to collect money. But before the Constitution, there were some lands that were private. They were sold as freehold, which at times we call alienation holdings. We have some in Central and other areas. They have,
but they are very small.
They are very small.
Okay.
There are some lands that we cannot go and collect any money from them.
I see.
Because they are private lands, and we need to respect that.
Okay.
Thank you.
All right. Thank you.
Prof. Chair, with respect to enable us increase our capacity, we've enrolled onto a digitalized platform to get an overview of the whole area that we are supposed to collect the revenue from. It's a work in progress, and when it becomes very effective, then as my colleagues are saying, you have that capacity to generate a lot of revenue. And that will also create employment for the team in youth of Ghana. Thank you.
Thank you. Okay. So just have a couple of questions to ask. The first one has to do with a suggestion that Prof. Jan made, that we should put you under the Lands Commission. I want to take a direct reaction from you. Then you also made a point about 45% of the revenue going to the traditional authorities and 55% going to the district assemblies. This is your proposal. Yes, I know. Okay, so you are just keeping to that. So it's not anything new you are suggesting. Now, what if I suggested to you that the challenge you have in collecting the revenue is because of a perceived unfairness in the revenue sharing arrangement? Somebody has his land, which would have collected 100%. Now you are saying that I'm going to change the arithmetic. First of all, 10% goes to you. The land doesn't belong to you. It's for the state. Then you now commute the remaining 90 into 100%. And of that, you give the bulk 55% to the district assembly. Then you split the remainder 20-25 to the stew and the occupant of the stew. I'm suggesting to you that it is because of the unfairness in there that's accounting for your inability to rake in enough. If it was made fairer, it should be easier for you to raise much more revenue from the stew lands. That's I want to have your take on this particular point.
Thank you very much.
Maybe finally, it's just a request. You mentioned 2 High Court decisions, one in relation to the Office of the Administrator of Two Lands not venturing into family lands, and you also mentioned that there is a High Court decision which says that Tindana lands are two lands. And I would like you to furnish us with copies of these particular judgments, if you have them. Thank you.
Thank you very much. I think your first question was our reaction to joining Lands Commission. The office is of the view that standing on our own, we can help Mother Ghana better, because given the 30 years, we've worked and structured our system in such a way that even the Lands Commission envy us. Yes, because we've put in solid structures, and we are not prone to a lot of, disputes. And then, as Lawyer Jan said, we have been able to distinguish ourselves, and then in that area.
But wouldn't that help you, the whole nation, since you've developed the structures? If you come under the Lands Commission's ambit, then you're able to collect more for the country and for yourselves, instead of standing by yourselves.
We were all here when the Lands Commission was restructured, and some of the divisions were added to them, like the survey and the Land Valuation Board. They are going through a lot of challenges. The survey people recently wanted to even pull out. It's not been the best. One would think that when we come under one umbrella, it will help. But in this very case, it's not proven to be the case. And we think that increasingly, our sisters at the Commission are being bastardized with so many things, such that if we remain at our end, we can serve Ghana better. And then the whole land sector would not be seen as having those challenges. We normally do joint programs because by us we consult, and we are sort of a moderating factor in the whole scheme of things. Now, if we go and the whole commission is bastardized, there's nobody to even look up to. So we are sort of cooperating with them from that direction. So that is what we think we can be on our own. The other issue that you raise, I think that is very important, that people are not paying the money because they think the law, the constitution is an intrusion into their personal land issues. We beg to differ because when you talk of communal lands, or even what the Constitution said, that two lands shall vest in the appropriate stew on behalf of the people, it means that the chief or the head of family owes some duty of care to a group of people, who are supposed to earn this area. It's a whole community. And of course, even when the chief disposes of land, to be able to identify who the citizens are, to be able to share those revenue. So the Constitution, knowing the communal nature of the lands, has come out with this formula, said that portions could be used for development for the whole area where the land is generated. What do we see now? Some people get the money and they don't contribute to any development in the area. We expect central government to also come back to develop these areas for which the lands have been disposed and monies found in. What we even have now helps them because when they dispose of these lands, they collect the drink money, but government makes sure we also collect the ground rents to be able to help in development. So it's like a double opportunity for the traditional people.
But why are you not recommending, why are you not proposing any change in the plan of distribution, right? So, because he asked if you are okay with it, 20, 25, 40, 55. You are also not proposing anything in terms of what that is used for, right? Especially the traditional authority one. If the stool is very vague and we don't know what maintenance of the stool is, what about the second one? Why are there no obligations as to how they use their money? You don't want anything, or it's too controversial?
Yes, Prof. Respectfully, the stool in that case, the one that goes to the stool, our ally, there's an ally which has defined what keeping in your status also means.
Oh, I see.
Yes, please. So it tells us at least what the stools can use that revenue for.
I see.
But when we talk about even projects that the office has undertaken, I have a KIT here, we all make this available. Some of the projects that assemblies have used the revenue for. So our office is the only office, perhaps, that makes money available to the communities directly. As for the one that goes to the traditional authorities, because they are lumped with the stools, we can also only say that perhaps they can also use it in keeping with their status, instead of going to touch it. But if we were to go into the law itself, it states clearly that all revenue, the chiefs take drink money before when they give out the lands, but we do not go into that area. We have restricted ourselves to the rents that are in their leases. That's what we collect and disperse, and other sources of revenue that comes.
And the recipients of the monies don't have any reporting obligations towards you. They don't have to show that the money that, even the district assemblies, when they get the money, you have no follow-up to see how exactly the money has been used. You don't have any remit in that area.
We have some control, especially with that of the assembly, because it is taking that revenue is supposed to go to the entire community. That is why we are clamoring that if some declare their land as family and other lands, it was a way of converting two lands away from family, or converting family lands from stool lands, so that they can then take all the benefits without anything going back to the community. So in that case, they rather cheat even the communities that they derive the revenue from. A case like Bawi, for instance, is a whole community, but they declare their land as family lands when it comes to that. They have a chief there, but they say the land is family land. The adjoining communities have stool lands. And when the assembly uses the revenue to put up a school or provide water, the whole community then enjoys. Thank you, sir.
Can I ask a quick question? Let's take the Bawe example. So your argument is that it's actually stool land, but they've declared it family land. Is that it, or it's the reverse? I'm confused.
Not necessarily so, madam. I'm saying that they say their land is family land.
Okay.
But if you look at their history or how the land structure is, you have a chief, you have, and it's a community. And
Okay,
if you look at the
let's
definition,
assume it's family land.
yes, please.
I'm just a bit confused. Let's go to the fundamentals. Where is the assumption from that you can manage my family land better than the family can manage their land? And isn't that almost a violation of people's constitutional rights to hold property? And if we follow that argument, when does something become family land? If my father owned a house, it was personal property. If he dies and he leaves it to 8 children, it now becomes family property. And you are telling me that would come under your jurisdiction? When does it come under your jurisdiction? And why do you think you can manage it better than I can?
Respectfully, if I may attempt to answer. The 1979 Constitution, in its wisdom, made family lands part of stool lands. Stated it that family lands were part of stool land. And then for now, we have a list of families that have even applied to our office. We have an MOU with them that want us to manage their land for them.
Yeah, but are you managing the land, or you are just doing benefit? You are just taking the benefits from the land and sharing it so that the local community gets a certain share of it.
Yeah, sometimes
people
people
managing the land.
Yes, people take it as if that we are only collecting revenue. But if you look at our functions, we go beyond merely collecting revenue. That's why.
Yeah, but I think you are getting yourself into a lot more trouble, right? If you stuck with benefit sharing, if you actually limited yourself to collecting the revenue that others have managed, we all pay tax, so it's like a tax, really. I manage my life, I manage my profession, my livelihood, but when I make money, the government is able to come and take some, right? That's fair. We accept it as the price you pay for citizenship, for living in this country and all of that. What you are getting yourself into, I mean, what I think Mrs. Sosai is saying, if your argument for family land being included in your remit is to say that the families cannot manage their land, or if you are seen to be suggesting that there is this kind of paternalism where the families are a bunch of illiterates, they can't do anything, then you are going to face obstruction and opposition. But if you limit your thought to saying that we are not trying to manage your land, however you manage it, when you generate revenue from it, we, by law, you must pay a certain portion to us for the local community where the land is located. Well, you may have a problem with that, but this is tax. It's like a tax, really. I mean, we pay taxes on that. But I think if you push the management thing too far, you could face a lot of political resistance because people are going to say, but why are you better able to manage my land for me than myself?
Okay. No, right? Respectfully, I was not saying that it's not only even just family lands. We have clan lands. Let's say if you go to the Volta region, they believe in clans. So it's the clans that own land. But in that case, we don't have stool lands there. We cannot go there because of this perceived definition. So when we say the family, it's not the individual families like, respectfully, Mr. and Mrs. and father who has their own property. But you tend to have whole communities that decide to say that our land is family land. Meanwhile, you can tell that the land is communally owned.
My Lord.
Volta region, where you say the lands are clan lands, what damage have they suffered by not permitting you to manage the lands?
My lady, with respect, in the Volta region, especially, okay, so that would be the OT region. The OT aspect of the Volta region has a lot of stool lands. But in the south, as you rightly stated, there are more family lands. What we are saying as an office is that we are not into the management of the family lands. No. You manage your land, clan, whatever. But whatever money is coming out of it, Mother Ghana must benefit in the same way as in stool lands areas. The issue are this, with the greatest of respect. Every land sold in Ghana is sold at the economic value. By operation of law, we are able to collect rents out of it. Ordinarily, if you were to collect rent on the land, then the land should not have been sold at the open market value. But believe you me, virtually every land in Ghana is given out at the open market value. And the people end up also paying ground rent, which is fixed into the agreement. It is that money that we are saying, if you are a family, if you are a clan, you have to also contribute your quota to the development of the locality within which the land is situated. Said that at the end of the day, if your land is family land and you are sharing it with me, whose land is too, we will all contribute equally to the development of Mother Ghana. I believe that is what we want to push across. Thank you.
Sorry, Mr. Chair. Okay, Mr. Chair. A lady asked, what has the community suffered when they declared their lands as clan lands? Until the passage of the Act 1036, people could grant freehold from clan lands and family lands, which you couldn't do with stool lands. So as we speak now, you can find some communities becoming landless today because they gave the lands out. Thank you. Yes. Now. Most of the families are not. Yes, I respectfully state that most of them are not able even to collect these revenues. They do not even have records of the lands they give out. Here in Accra, if you ask those of us here who has leases, and you ask how many of us know what even is in the lease, most of them do not even know the interest or what they've given out to you. They don't come even to collect the rent you are supposed to pay every year. So most of them rely on our office to do these collections.
So that's interesting. So now I'm understanding better. I understand Mrs. Osai's question. So do you collect from the assuming that you were collecting from families too, would you collect the revenues from the families, or you would collect the revenues from those who owe revenues to the family? So a multinational company sits on family land. Would you be the one collecting from the multinational company, or you would collect after they paid the family, then you go and ask the family, give us our share for the assembly? At what stage do you collect, and from whom do you collect?
So, my Lord, if we relate to say...
The only Lord here is this one. We are all plebeians. All of us are plebeians.
Okay, Chair. For instance, we have big estate companies in Ghana. Mm-hmm. I mean, the Regimanuels, the Trasacos, and what have you. But ordinarily, they have come into our country to make money out of our landowners, and we've put our landowners at a disadvantage.
Point of correction. Some of them are Ghanaians. Regimanuel is Ghanaian. They didn't come into our country.
So there may be some multinational companies, but whatever it is, what I want to say is that at the end of the day, land is for the dead, living, and the yet unborn. If we structure our land administration system well, as we are, we seek to propose, the land will generate perpetual money for the development of the immediate vicinity that will always add values to the land. I read a judgment, I think it's the Lakeside Estate judgment, when they took the lands back about the 70s at what today will be peppercorn, but the company is benefiting at a great length now. Could they share the benefit they are getting in a way with the landowners and with the people of Ghana for the development of the locality? That is what we are proposing for. So, my lady, sorry, madam, the issue at stake is that what harm are we seeking to cure? What we want to do is that the money from the land that you are benefiting from should not come to you alone, but should go to the society at large so that there will be equity and fairness in how we generate resources from the land for the development of the area. Thank you very much.
So maybe in some other jurisdiction, the solution will be a tax, right? Everybody who owns land in the community pays a wealth tax or something, right? So basically that's what it is, right? It's not, is it different from property rates? Right? So it's different from property rates, right? What you are collecting, the assembly still collects property rates on this asset, right? Yes. And so what exactly are you collecting? I mean, that differentiates it from what the assembly is collecting. I think it's really to understand exactly the function you are playing here so that we know clearly where the lines are. I thought I was getting you until you said you collect for the family, right? I can understand somebody saying, but we are not a bunch of, we understand we are a family, we own this land. We can collect it ourselves from, whether it's from a Ghanaian company or Blue Skies or wherever. We know the value of our land. We know our land. We can transact it with them and collect our rent. Why do we need you to collect the rent for us? And you're saying, no, it's not about collecting the rent. It's about sharing the rent so that the community gets some share for the privilege of having you in the community. But then my question is, who are you? Who is doing the collection from the rent owner, rent payer? Are you the one collecting it directly, or is it the family that must go to the rent, the tenant, and say, give us our rent, then you come and say, you've gotten your rent, give us our share for the district assembly. How does it work? Oh, you collect from the tenant.
Chair. Yes. So, Chair,
but what do you collect? Do you, because we have rent and rates. So which one do you collect?
We collect rents. We collect by our law. We are supposed to be collecting rents, dues. Let me quote the law. I'm reading from Act 481. So it says that the Office of the Administrator of State Lands is established by Clause 2 of Article 267. And our mandate is the collection of rents, dues, royalties, revenue, or other payments, whether in the nature of income or capital, and to account for them to the beneficiaries specified in Section 8 of this law. So the family in this case becomes the beneficiary. They have sold to people their lands. They've gotten their monies already. But annually, we go based on the law to collect this money, and then we account to them back. And then some, in this case, some will go to the Assembly for Development. So it's not like we are going back to the family to go and collect what they have already. No. They have collected their money, some premium, some advance payment upfront. And some are okay. They don't even know that there's subsequent rents to be collected. So we do this job. And a lot of family heads come to our office, get their share, and then we go on. But it's only that we are bringing this because when the families come, they get all the 90%, and none goes to the Assembly for Development.
So the head of family accountability law, right? So that's there to cure this old problem of family heads collecting monies and not accounting to the family. But you are doing some of that. You are doing what the law now requires head of families to do in terms of accounting to the families. Are you doing the same thing that law is requiring family members to, family heads to do? Are you ensuring that they are following the law? Is that part of your role? Yeah, I just want to understand the boundaries, where this runs into that and all of that.
Chair, thank you very much. If you permit me to come in. So back to basics. You collect rent. How do you collect the rent? So we come in at the point after the land has been granted to the lessee. So the chief gives you land and an indenture is prepared. Usually the indenture will have a clause that requires of you to make a yearly payment of rent. That is when we come in. It is not at the point at the beginning where the drink money now converted into millions of money. So people ask that, what kind of schnapp or what kind of whiskey will cost so much in dollars? So it is at that point that we come in, and then we follow up on the lessees by submitting to them what we call rent demand notices. And then they come either to the office, or we have revenue collection officers who do door-to-door, land-to-land collection. And so that is how we then come in. But yes, that is it.
And then people say, we don't know you. We signed an agreement with us too. Why should we be paying our rent to you? Sometimes, even the land is freehold, and yet they are served with such demand notices when the people are not expected to pay any rent.
And that is on the operation of the law that requires of us to do the mobilization. And yeah, so we are.
Have they held stakeholders consultations with the people to explain this aspect of the law to them? Because there are people running to us asking questions. Why do I go and pay my rent to someone else? I didn't sign any contract with the person.
AG, yes, AG.
Stakeholders.
We continuously hold stakeholders workshop. I think the last one was last year, where we held a stakeholders workshop. We normally convene for two sectors, for chiefs and then for heads of family.
I see.
We do that periodically and explain to them. I'm surprised that people are still asking.
They are still making complaints.
It's surprising though.
My other question, which I want him to tag on, is that we have something we call District Assemblies Common Fund. Huh?
Yes.
These are money supposed to go to the district assemblies. Why do you still take money and give about 55%, stools money, to same local government when the state is paying about 5%? I just looked at it. Subject to the provision of this constitution, Parliament shall annually make provision for the allocation of not less than 5% of total revenues of Ghana to the district assemblies for development. Why are you collecting stool monies?
From the central government. That's from the central
252,
government.
yes.
Not from the.
Yeah, but it goes to the assembly.
Yes. The whole idea.
More is better. More is better.
It's going to the same assembly. And you expect them to pay?
We should be asking.
Well, I think the principle, maybe what we are trying, I think the principle itself, at least I'm understanding what you're saying. I think the challenge is how you're doing it. If I am a third party who contracted with the landowner, right, whether it's family or stool, and I wasn't aware at the time of contracting that I owed you any obligation at all, and then you came in after the fact and said, I am supposed to pay my rent to you as opposed to the landowner, it seems a bit that's where the problem is coming from, right? Is there a way that this problem could be sorted out, which is where, Honorable Ikotu is saying, when they were making the contract, you were not there. You were not part of it. You were not part of this transaction. And then you come after the fact and say, but you owe the rent to me. And I collect and I give the family some. And I give the district some. Right? I think maybe the sequence, at what point you come in the process, is part of the confusion. But I think the principle that you have land situated in a locality, that locality should benefit from the economic whatever that accrue from the land is generally, I think for me, the principle seems okay. It's like a tax of sorts. But how you are going about it or how the law allows you to go about it is where you are encountering these problems. And that's why everybody wants to escape your jurisdiction and not want you to collect anything.
Mr. Chair, respectfully, in the indenture, you see, respectfully, a lot of people do not read the indenture. It states that rent will be collected by the Office of Administrator of Students. Some of the indentures.
No. They don't put them there.
Is it required by law to be in the indenture?
Yes, in the indenture. Some of the student.
No.
Yes, in your indenture. If I have a copy here.
At all.
It is not. No, my lord, it is not so much of a private transaction. Not only mineral concessions. No, it is not only mineral concessions. No, leases. The leases that, if you have an indenture, for instance, now, maybe tomorrow, God willing, I can bring a copy of an indenture which shows that rent that is supposed to be collected. Insofar as it is stool land, the administrator of stool lands has been mandated to collect.
Then somebody put it in the indenture, but it's not common. It is not a common practice.
Madam, Lands Commission, people mistake us for Lands Commission because those monies that are paid to. No, I'm saying some people.
My house is a government lease.
Yes, that one to Lands Commission.
I pay to Lands Commission.
Beautifully.
But the last time I went to pay my property rate, because New Driving Kofodia has been divided into north and south. And they told me that the rent, I have to pay it at a different place now, since now I'm not New Driving North. And they mentioned that there's a school land office there. So I got confused. But I haven't had time yet to go and find out. Because I pay it every 5 years. When I go in the assembly, I haven't had time. They mentioned something about school land office there. And I was surprised because when I was going to the Lands Commission, there's no mention of school lands office. So are you now in the Lands Commission office collecting ordinary government ground rent?
No, my lady, yes, there are various categories of land. But in most of these cases, because stool lands, you cannot grant freehold out of stool lands. All the leases granted show that you need to pay rent. And it is the responsibility of the Office of the Administrator of Stool Lands. These rents have been collected since 1962. And in those periods, family lands were even part of it. It's the 1992 that the word family was left out, and we are trying to bring it back, and we've showed all the arguments that, but we agree with Honorable that education should be continuous. People get these documents, they don't really know their obligation within the documents. And for some of the chiefs, after they've given it to you, collected their money, they are gone. But in these documents, when it says stool lands, clearly the rent element is shown. And our office collects those money. Your ladyship, I think that what you went and paid is ground rent that you went to pay, because we have an opportunity of paying every 5 years because it is reviewed after every 5 years. Yes, but with the assemblies, it's a yearly tax that they charge.
Rate,
yes, that's the property rate. But with the stool lands, every 5 years, it is reviewed with a new rate. And it's in there. That is why you were directed to Stool Lands. But people
No, in
mistook
my
us.
list, they didn't mention Stool Lands.
Yes, yes.
But now we have to be paying. They say they've created a new office for not New Job in North.
Yes.
And that Stool Land, they mentioned Stool Lands office.
Is your office is the lease a very old lease?
Yes, 90, let's say 95.
Yes. So you realize that at that time, maybe Lands Commission was collecting those monies.
Yes.
But then when the office was created and the new administrator came in 1996, all those tax being done by Lands Commission was handed over to the Office of Administrator of Stool Lands because of the new act. So we continue from there. So it is not a new thing. We are only trying to seek this committee to strengthen our hands to be able to do the work effectively, for the assemblies to get a lot of money to do all the developments, whilst also assisting the families in a way that we can, because if they become our clients, they definitely, with the expertise we've gained over the years, will help them. Many people come to us and they even wonder how they should even prepare the indenture and all those. So it's like an engagement. So those are the things. We will not go and try to bully people. No, we are doing things in the confines of our law. Thank you.
Okay, about the percentages, are you doing something about it? Because I remember they came to the Supreme Court, and we say it's a constitutional provision. So unless it's amended, but we cannot, in our judgment, amend it. So have you done any? You were even parties. You were defendants in that case. I've forgotten the title of the case. I even wrote an opinion. Yes. Yes, some chiefs who came. So what have you done about that?
Madam,
so that if you are amending things, then we have to look at the percentage.
So, my lady, the issue about the apportionment,
yes,
I believe the House of Chiefs will be coming out with a position on that.
Okay.
And being a body that we ought to be seen as neutral, we ought not to be going there now. Other than that, when any of the functions are not happy with our proposal, then the work that we are doing also becomes difficult from their angle. So I'm certain that the House of Chiefs may make a proposal on the apportionment, because that is an area of great concern to them. Thank you.
Thank you.
Well, you mentioned that there's an ally that defines or elaborates on this for the maintenance of the stool thing. Could you give us the citation?
Yes. We have an ally here. I will go there. But respectfully, I wanted to...
Sure, absolutely. Yeah, it would be helpful.
Yes, whatever I have secretary.
And maybe one last question before you answer back. I mean, in terms of the structure of your office, would a commission model not be better than this office of the administrator of Stool Land? If you had a commission model, like a commission, as opposed to office of the administrator of Stool Land, so that you can have, membership from diverse stakeholder bodies, some of these kinds of, because if you are just an office, if you were a commission, we could nominate, chiefs could be on it, local family clans, or, a number of different entities could be on it. That would probably give you the kind of multi-stakeholder appearance, at least. That might help your work. But if you're just by yourself, an office of Stool Land administrator, how does it help or hurt your work? I'm just looking at other possible ways of doing your work.
Yeah, Mr. Chairman, thank you. If my memory serves me right, the Constitution Review Commission's work in 2010 proposed this commission structure, but I think government did not take it on. Government did not accept. So I think it's something we can look at again.
For now, we cannot tell. If you don't make decisions unwieldy, we can go by it respectfully. We have operated this system
office model, yeah.
all this year, and we have all the way. We
So
cannot.
you are comfortable with this? You are just used to this model.
But if there's a better way, we'll be prepared to perhaps.
But we wouldn't know. What's your better way?
As an office,
Okay.
we've looked at it.
The commission model.
Yes, or a board like something. We've looked at it. It even went to the Attorney General, came back, and it was shut down.
Okay.
Because I think the mindset was that the framers of the Constitution did not wanted it to be a form of an independent body. So they did not create the board. That was the concept they had. That is why, as recent as last year, you had even proposed a board, but it was shut down. So thank you very much.
Mr. Chair, I wanted to make a small education. One, you asked what is the digital assembly, what they collect. That is the intokrator. The property rate is intokrator. But what we collect is assassetor. That is for the bare land. Even if you have not even developed it, you are supposed to pay. So that is what we collect. And respectfully, the Lands Commission also collects some form of ground rent on state land. So that is the issue. Thank you very much.
Yeah. Yeah.
Thank you, Mr. Chairman. In terms of your mandate, whether or not a land is true land or it is family land, the number of decisions of the court in Oble versus Ama and those line of cases, Bruce versus Quino and all of that, that decided that a subject of a stool has an inherent right to reduce unoccupied or vacant land into possessing and farming that his energy and effort can take him. There are several decided cases that said this. Now, what it means is that the size of stool lands, as they used to be, automatically by the progression of time would reduce. So if you were dealing with a land properly categorized as stool land, and by the incident of occupation by family, subjects, two subjects, and the two subjects, what happens is that progressively they pass on this land from one generation to another generation, and they metamorph from stool land into family land. So you may actually be talking about the same land, which properly is a stool land, but it's also what? A family land. In dealing with the issue of families declaring their lands as family land, what does that actually mean? So you may have to take cognizance of this development, and in those cases are still valid. Okay, they are still valid in law. Even the same courts have held that the stools themselves expressly can grant stool land to strangers. This Kofi versus Ati Brukusu, there's one case like that. That even non-subjects or non-indigenous can also acquire land from the stool and develop them and progressively become family land. So if you say they have declared it, what does that mean? Now, my second question is, most of the stool lands are in dispute. There's a lot of dispute on many stools, across the length and breadth of the country. How do you administer these lands for purposes of distribution if you have 2 or 3 stools that are in dispute over the legitimacy of a chief? And they brought court injunctions and everything to stop a particular chief from functioning. Because you have to work with a recognized chief by law. And by law, a chief is someone who's been gazetted. That's the definition of a chief, that he hails from the appropriate family and has been nominated, what are the other terms? Nominated and by customary rules, and has been gazetted. So, and installed, selected. Those are the alternatives. Nominated, installed, selected, and all of that. So at every point in time, if you don't have a selected or a consensus that there's a chief in a particular stool, and the stool has land, how do you deal with such situations? Did you get my question?
Thank you very much. I think this your question is even in support of what we want to advocate. No, you see, the first question that stool lands can be given out to usufructs and all that. That is why in the wisdom of the definition, we think that stool lands should include all these categories because they come out of it. You shouldn't appropriate it to your private, it becomes, if it's part of your family, the family may be still within the stool, and the rent that we have to collect for the betterment of the society. So what we are saying is that it could be a family land or a clan land under the stool, but you still do not really say that it becomes private. So therefore, when we are counting, you were talking about jurisdiction. If the jurisdiction of, let's say, a particular stool is this room, whether portions are being occupied by the family, the usufruct or clan, is still the jurisdiction. You get it? So we don't, the situation of stool land revenue in our law is said that each of these categories within the stool land area, whether family or not, should be classified as part of the definition if the stool is defined to include family and all those things. So those are species coming out of this particular land so that they are all captured and somebody will not take part of the stool land away. And if the stool land is 600 square kilometers, in the next 100 years it becomes 200. No, that is not what we want. So that is the answer to the first question. Maybe the second question.
Yes, please.
But have they found out why the family was excluded in this definition?
Well, it wasn't excluded. It was just it's just a weird definition.
No,
stool lands includes.
No, they are saying it's always been there.
And then they were taking out this time around.
Yes, the family
so there's a
has
clear
been
intention to exclude.
There should have been an intention. Why don't you go and read the experts' opinion? Those who crafted the Constitution, why they decide to take it out?
Okay. Hmm? Yeah.
And I think the fact that there are disputes, I thought the point we were going to make in response to our secretary's submission was that the fact that there are so many chieftaincy disputes probably speaks in favor of having your office, because whether or not the land is still in dispute, you are entitled to collect your stuff.
Exactly.
If you can't pay, you can't find a chief to pay to, you can always pay to the Office of Stool Land Administrator, so that you will hold it in reserve until the dispute is over.
Exactly.
Right? Is that not the practice?
Yes.
Whether there's a dispute or
not. And the beauty is that, with the assemblies, there are no disputes. So they will be getting their portion for development. Whilst at times the stool's portion is kept in suspense accounts and all that.
All the time you hold the school's portion. Always. All those places. Play the disputes. Yes.
Who did they give it to?
Well, they should have found a formula. Somebody must be in charge. Somebody must be in charge. They are holding the monies. They are holding the monies, claiming that they don't know who to pay to.
Who is the chief? Yeah.
Chair.
Thank you for your. You have one.
Just a short one. Just to add to the issue on the dispute and what happens if there is dispute. So we hold back on the monies. Unfortunately, maybe we should have discussed that we are not permitted to invest such monies. And so we hold on to the monies and,
in a non-interest-bearing account.
In a non-interest-bearing account. And in our system where the CD depreciates so fast, if we hold your money, if we had it 1-to-1 in 2007 and the dispute is still subsisting, 1 CD to $1, now you can imagine what the money
You are not allowed to invest in treasury bills?
We are not permitted. So that is, yes, we are not allowed to do that. But there's a bill in the process to cure this problem. And I'm not sure if our rapporteurs have captured our position on Prof. Jan's question whether or not we want to be subsumed under the Lands Commission. the rapporteurs should capture it categorically,
so you want to be a
respectfully.
sovereign entity.
Yes.
It's been captured.
Yes, please. Thank you very much.
You don't want to be part of the Lands Commission. You don't want to, but you want to sit on their commission. You want your nominee to be part of the Lands Commission. You don't want to be part of the Lands Commission. I think I captured that one, right? You want to have a nominee on the Lands Commission, or at least at the regional level, but you don't want to be part of the Lands Commission. Very fair, very fair. Okay, I think we can do the. We have until the lunch is at 2, so we will go to the Ghana Dangbe Council, and then we'll go back to a gentleman from the Lands Commission who is speaking in his individual capacity.
Okay, thank you, honorable committee members. Our story is very simple. Everybody knows. Since Accra became a capital, there has been a lot of pressure on the Accra lands. And these compulsory acquisitions started long before, Ghana became independent. Most of the lands were acquired even by the colonial governments. And now we have a lands commission which is supposed to manage these lands. I think that in 1992, thereabouts, when they were looking at the new constitution, they realized the difficulties that the Gandangwe people were going through. So they came out with Article 20 and its subclauses. That at least it became clear that the lands are taken and they are never used for the purpose for which they are acquired. And they are given to individuals who benefit. Recent phenomena is where you have bungalows which were put on 1 acre lands. And now these are being given to land developers to do what they claim high occupancy, accommodation for people, 4-story, 5 stories, as well. So those from whom they took the land are never factored into these things. They just take the land, give it to a land developer who goes to demolish the old structure, puts up a 6, 7, 8-story, gives part to government, and gives the rest to individuals. The people are suffering. They don't have cash. And no attempt is being made to look at their interests. They are becoming jittery. I was just telling Madam who said that we shall take off cutlasses and cudgels very soon. So then the attempt was made by others to go to court to say, look, looking at Article 25 and 6, if you are not using the land for the purpose for which it was taken, why don't you give it back to the pre-acquisition owners? Then Supreme Court of Appeal said no, it has no retrospective effect. Now in the Ni Bobby Tetechu case, which was decided by Supreme Court, I think Peter Lajeti and his people went back for review. And at that stage, 3 very respected Supreme Court judges, our madam here, Justice Atuguba and Safa Akufu, said they think that the definition they placed, the interpretation they placed on it was wrong. And that if all the lands are being managed as public lands by the Lands Commission, then why don't you apply the same law? Why do you say that this one there is past and gone? So they wrote a very vigorous dissenting opinion, but they still lost 4-3. They still lost. And so we are looking at this as an opportunity to look at their view, where they are coming from, no matter when the land was acquired. So long as it is not being used for the purpose for which it was taken, even after the coming into force of the 1992 Constitution, the same rules should apply, that the pre-acquisition owners can come back and ask that the land be given back to them. We are asking that if there should be a new clause added to 20, that those provisions, 5 and 6, should be applied even when the land was taken before the coming into force of the Constitution, as they propose in their review. Now, having sent it to you, then this issue of public use and public interest came up. Assuming that were done, and then the people tell you that, but we gave it to estate development, and the people have used it for estate, and everybody has benefited. What will you say? So that is where the problem is now. How do we define? Because most lands are supposed to be taken in the public interest. Is there a way by which we can use language, which would define what that public interest is? That public interest cannot be when it is given to an individual, a private individual who is making money, off other members of public, and you are telling us that it is still in the public interest. It's an individual. Last week they told me about something somebody went and saw somewhere, written Akma Owusu Ajiman something block. And it was, how? A land taken from Usustu now is being converted, it is somebody's block. It's just built houses on it, and it's, So the people of the Dangme people are suffering too much. Apart from the compulsorily acquired lands, a lot of the lands were also vested, especially in the Dangme areas. In the Dangme areas, a lot of them. Those taking vested for cattle development, Bank of Ghana, so and so. They abandon the project and then sell the land, divide it among themselves. They don't care about the people. We need to do something about the situation. It's becoming dire. Now you ask for divesting, and that also becomes a huge problem. But recently, some lands, prime lands in Kumasi, were divested and given back to the Asante. They were all divested and given back to the Asante. And then they put it in the papers, in the newspapers, and on air, that henceforth, whoever wants land in that area should go and see the Asante. Meanwhile, ours, they say go and see the lands commission people. And they have turned it into a pot of gold. They've turned it into a pot of gold. They're just doing whatever they like with the land. This is our last chance. And so we are pleading with you to do everything possible. In fact, we intend to bring a supplementary submission on some of this public interest. And because when we did it, we forgot. But it was later on that people started raising. My friend, even if you go and they say the thing would be applicable, and they are telling you it has been used in the public interest, what would you do? And then, is it possible that when these redevelopments take place, maybe some rent, some part of the rent is given to the pre-acquisition owners, so they also become, or if you build a 7-story, can you give part to them? They also need, now they are all clammed up at Bukum, Choco, and some places. All the lands have been taken away. Where they are now to expand is no longer possible. And it is not their fault because that land is a capital. And I used to tell them, we grew up in Accra. They tell you, go and put on the light. You just go and switch it on. Go and fetch water. You just go and open a tap. Your mother is going to church. Hey, stop a taxi for me. In those days, the taxi will wait for the mother to finish whatever she's doing. Then they take her to the church. Do they have those facilities in wherever they are coming from? People have not seen lights. It's not easy to get drinking water. I remember going to a village and they gave us water to drink and it has been brought from the river. I looked at the fair and said, this one, please, I can't drink. It's not possible, I can't drink. So we are somehow blessed that we had the capital, but the opposite effects is affecting everything, including our language. I am 71 years. I grew up in those days when people were now coming to Accra. Everybody was learning Ga. Anybody can speak Ga with you. Today, they tell you Sakasano. just because we have been overwhelmed, by the number of people. And it is not fair. It is not fair. We never asked. And remember that we were living here before you moved from Cape Coast. It is not that we founded it. And our people go to school and the children say, we come from Jamestown. They say, no. Everybody comes from a village. And I said, let me go and talk to that teacher there. Who tells him? When they moved the capital from Cape Coast to Accra, were we not staying here? Who were they here before they came? So we have no villages. These are expansions that they have done. These Ghana villages that you now see, they expanded. But we were living here already. And so we want, like Prof, before he left, was saying that the fight should not be for only Gadangbis. Otherwise, they will see us as a small group fighting the whole. So we need everybody's, input to assist us to solve the problems. I remember this Northern Lands matter. In view of the constitutional provision that the lands had been divested, Bright Akwete went to court, I think Omabu versus Attorney General, to try and see if the Osu ones could be. They said, no. If Parliament wanted to divest Accra lands, they would have said so. But it's land, not land. It's land, not land. Those they were giving at the time, is that not land? But we were deprived. So we are on our knees. We are here. We want collectively that you assist us to resolve this matter. This collection of rents that we are talking about, they are not paying them because the guys are fighting. They say there's no chief. We don't know who to pay. Meanwhile, there's somebody every year they organize a war. There is somebody who goes to speak that quickly. They know that there's somebody there, but deliberately they keep the money. They don't want to give it to them. They don't want to.
So, in terms of the work of the committee, one, you want the Supreme Court decision this about this non-retroactivity of whatever.
Yes.
You want that decision, more or less overturned through this process.
Exactly.
You want the language about compulsory acquisition for a public purpose or public interest. That's all public interest bit you have a problem with.
We have a problem.
So you want a different formulation that would link it much closer to the stated purpose.
Exactly.
So if you had something like stated or related purpose or something, you would like that better. And then the third proposal for us would be what?
The face of the EI that is used to acquire the land, they should state the purpose clearly.
Sure.
They should state the purpose, and that should be the purpose.
Well, but it's still, Professor Jan gave examples, right? So you take land for a university. Then the university's population, grows to 50,000. And certain services become more or less...
They are incidental. We understand that one.
Good.
But when they go and give the land to private people to do all sorts of things along the university garden, the former...
Sure.
They've given it to private people who are making money out of it.
Now, that is it's a controversy in many places. I remember a case in Michigan where the state of Michigan took land, and I think for them, the constitution, the language was for a public use. Public use. It's not public purpose. So there's a public use language in the constitution that gives the government the power of eminent domain. You can take property for public use. And they took the property and gave it to Ford Company to build a factory. And the question for the Supreme Court was whether taking land from one party, a private party, a family, whatever, giving it to a private company to build a factory that would employ people in Detroit. Right? This is a community that needs jobs, right? Whether that qualified as public use. And the court said yes. Even though it was a private entity to whom the land was being given, the purpose in terms of helping to create employment for the community in a generally depressed urban area was a very good public purpose. So this is controversy, not just Ghana. right? It's all over the place. And the language is always at the heart of this dispute. So you're right. If we could do something about the language to prevent the abuse of that power, so that you don't really, and the general principle is that you shouldn't take land from one private person and give it to another private person. The government shouldn't be doing that. So that is the purpose for the public purpose language, limiting or constraining this kind of redistribution for private interest. But so yes, so you can propose some language. If you think that is the problem, we can look at the language and maybe tighten it and prevent this kind of abuse of the eminent domain power. There's asymmetric, I mean, on your last point, I mean, this is very important. In some constitutions, you find the capital city area is always a special case.
Exactly.
So asymmetrical treatment of the capital city, it's not strange, right? Like it was done for the lands in the northern region.
Yes.
Maybe that could have been done also for Accra land because it's a special case, right? Is there any proposal? I mean, do you have any very specific way this could be done? I mean, this is way after the fact, you know. A lot has happened since colonialism. So sometimes when you are coming to a problem generations later, it becomes very difficult to solve because so much water has passed under the bridge, and how exactly you undo all of those centuries-old, generations-old problems becomes the difficulty. Is there some way your organization has thought through how this problem can be solved going forward? You know, you talked about the divesting issue. You know, is there some, have some concrete thoughts on how we might do this, if it's possible?
Well, we can look at it. You still have some time. But when we look at your schedule, we had to present it by Thursday last week or so. So we rushed and brought something. But there are a few other areas where when we get to those semantic areas, we should also come and talk about. So we'll go back and, because it's one thing that is worrying all our people. And it's not only us. After all, being a capital, there are a number of mixed marriages. There are so many people who have married Ghana people, and they also fight along with us. You know, so we'll see how best we can look at it. But this is the only opportunity. But the Supreme Court's decision stands. It's not changed. And if we can use a constitutional way of striking those things down, then that will be better. Otherwise, going to court is a complete waste of time. You will be met with a superior decision from the Supreme Court.
With all due respect to Honorable Ayukotu, you missed the opportunity in having the Supreme Court follow the minority decision in Tetesru in a case which followed almost immediately. Samokuje to Blakwa and Nanda versus Obechebi Lamte. The plaintiffs, the defendants never, or the plaintiffs, none of the lawyers before us referred to that case, which was quite recent. It was only on review that they were saying we didn't apply that case in the judgment of the Samokujeto case. And it wasn't, yes, Samokujeto Ablakwa and another, versus Jake Obechebi Lamte. Yes, what I mean, it was in review that you wanted the court to follow Tetesru. So the barrier against you was that you didn't even raise it, bring it to our attention. So you can't say the judgment was per incurrum when you didn't refer to it. And then also, so I feel that the Ghans missed the opportunity when this case came. They should have, all lawyers should have joined together and did real research, because even the first instance, the Supreme Court didn't want to take the case. But I wrote a judgment that it raises a constitutional issue to be interpreted. It's not simply a land matter. Yes. So, and it was strongly resisted, but I was able to convince the whole panel that we should take this case and then do it. But I was disappointed in the arguments filed and everything. It wasn't sufficient. And then it's not for us to do your case for you. So you missed that chance. Because they could have applied.
This is the time to rectify that. No,
Yes.
I wasn't.
So
I
let me
wasn't.
just ask
In fact,
a last question.
yeah. Yeah, Brabe wrote the late judgment. I was in court. Change the whole thing. Yes.
Okay,
So,
please,
so this
Chair,
is the
I just want to
opportunity
ask.
we have now.
Okay.
Oh, I see. Before coming, yes. Yes.
Okay, please, I just want to ask Ni a question. You know, we spoke about situations where land is taken for an intended use, but it's not used for such a purpose, and you want the land back. I want to find out from you, would you be in the position to accept a situation where instead of having the land back, part of the revenue is given to you?
That could be an alternative. That could be an alternative if the land has been developed. You know, high rise, 6-story, 7-story. Give us part so we can also settle our people and give us on rent.
So that's something you should consider in your right.
We do. We have been thinking about it. Yes, we have been considering it.
Okay.
You know, it's not easy. It's the same with the language matter. They are not speaking the language, they are not teaching the language, and they tell you that predominant language has changed. We'll come to that when I come here to speak about that one. Yeah. Yes.
So if getting back the ownership is difficult because a lot has happened over centuries and whatever, then the benefit sharing is where you should probably be looking for the remedy.
That is one way.
So if it cannot be reversed because they've built stuff on it, you can at least still get the benefits, right? So it doesn't have to be either or.
Yeah.
That we either get the land back or nothing.
That is
Right?
for those perhaps not those that have not been developed.
Yeah, but if it's already been developed, and what we're saying is that Accra is rapidly developing into these things. And if you are unable to get if you insist on only one result, we want it back, then it may be difficult to get it.
I know.
And so you then have to do, the second best option is, then we want to have a share of the benefits. You know, it may be the most pragmatic kind of outcome that you get in a situation where so much has happened.
I have been talking to them. I've even telling them that land issues are too complicated and I don't want them to get involved. They should leave it to the lawyers because there's a lot of passion that comes with talking about Accra lands. Now, if you are not able to, manipulate them a bit, all kinds of things will happen. So we are looking at that as well. I've been talking to them. If they are still some freelance, fine. But what is happening is that those ones that sit on 1 acre plot, small bungalow sitting on a 1 acre plot, that is what they're still using to make quite a lot of cash. Sorry. You see, those ones are also, just going. Well, as we do this work, we'll do the underground work also to see. If indeed they are not there, we look at the other option as well. Yes. Yeah. Yes. Yes. Mm. Mm. Oh, of course. The president during his campaign told them that he was going to set up a committee to go into those matters. And so we see this as part of his committee, and it's even bigger than the small committee would have set up, because that would have dealt with only land matters. But this is dealing with a constitutional matter, which are quite, serious. So
okay, great. Thank you very much. We would be expecting maybe supplemental
yes.
Submissions based on this conversation. Thank you very much. So that would be probably the last we have before lunch, or do we have to go to lunch and come back? Yes. It's 2:00 now. Should we break, have lunch and come back? Would you be okay if we took lunch and then came back? Then you'll be the last? Or we should just take the last one and then we eat and go? Okay. All right. So if you have some energy. Oh, the lunch closes at 3, so we cannot eat after 3. We should go and come back? Okay.
Okay, very well. I'm Lawson Bosokin. I work with the Lands Commission as a land administration officer. This presentation is here in my own personal capacity, so it does not represent the opinions of the Lands Commission in any way. The presentation is on strengthening customary land management through improved ground rent collection, formalizing lease renewals, and institutional reforms. So first, I would like to say that with the coming in force of the Lands Act, Lands Commission and the Lands Administration regime has gone through a lot of changes. In the current scheme of things, the Office of Administrator of Stool Lands collects ground rent on stool lands, but their mandate does not extend to family and clan lands. The Lands Commission also, as an agency in land administration, we collect revenue on state lands, especially state land ground rents, and then we perform other functions relating to customary land management. That's granting of concurrence for customary grants, and then registration of customary grants. In doing all this, there's been a lot of difficulties, particularly relating to the splits in the functions in customary land management and lease renewal practices. Some of the limitations we face currently relates to the fragmented land revenue management regime, where the Lands Commission collects revenue on state lands, and then the OESL collects revenue on stool lands, and then the families collect their family land revenue. In all this, we realized that there's no transparency in the way these land revenues are collected and managed. And then we've also had difficulties with how customary leases are renewed. Our recommendation here is to extend OESL's mandate to all customary lines for a unified land revenue management regime. So all we are saying is that the OESL's mandate, instead of just limiting it to collecting revenue on customary lands, they should collect revenues for all categories of lands. In doing this, the OESL may have to be integrated into the Lands Commission as a rent management division of the Lands Commission. And to do this, we are suggesting that there should be a legal framework where there will be a smooth retention of OESL's technical expertise within the Lands Commission for all land revenue mobilization. And to ensure this is done, we may have to take a look at some of the constitutional provisions. We may have to look at Article 2675, which prohibits granting of freehold interest in stool lands. What that means is that now that you're going to be granting leases and tenancies, you have to be collecting all ground rents from all these lands. And then when you look at the Land Act, it also extends the prohibition of clan and family land freeholds. It's limited as well. So with Section 9.2 of the Land Act, families and clans cannot grant freeholds. Essentially, what that means is that families and clans, in granting their leases, they have to ensure that ground rents are paid. Now, who is going to be collecting all these ground rents? There has to be a defined body to be collecting these ground rents. And then all the incidences that apply to stool land ground rents should apply equally to such family lands. Particular to mention will be the revenue sharing arrangement for all stool land revenues. I am saying that the same formula should apply equally to clan and family lands. And why are we proposing this? Because there are certain benefits that we've seen from OESL collecting such ground rents over the years. We realize that the revenues collected by OESL in the form of ground rents have served as an important source of revenue for local authorities. With the 55% that goes to the local authorities, it helps support them in a lot of their administration of the local areas where these lands are located. So if we should extend this particular formula to family lands and clan lands as well, it would also encourage to serve as a good revenue base for the local authorities. For instance, in the Volta region, where we have limited stool lands, what that means is that landowners are not contributing anything at all to the revenues of the local assemblies. Whereas somewhere in the Ashanti region, where mostly all the lands are stool lands, the landowners are contributing a chunk of their revenue to the local assemblies. I think this is unfair, and so such arrangement should apply equally to family lands as well. With OESL collecting ground rents, we have seen that they practice over the years an expert form of assessing ground rents. So the ground rents that are paid and reviewed periodically by the OESL are not assessed arbitrarily. There's a standard approach to it, there's a method to it, and this has helped encourage people to pay more ground rents. Whereas when you go to the families, the ground rents are arbitrarily determined. So there's no particular formula to tell how much you're supposed to pay periodically as your ground rents. I may resist which amount the family requests me to pay. So we are saying that the OESL, having this expertise in assessing ground rents, it should extend to all categories of land. And then if OESL collects all these forms of ground rent, it will serve as an important data set for land administration policy arrangements. One difficulty we face over the years is that we don't have reliable data relating to revenues that may accrue from land. So you come to the Lands Commission, we can give you some data on revenues you've collected on state land ground rent. You go to ASL, they can give you some data. You go to some families, they may give you some data. But we need a one-stop shop where we can get all the relevant data relating to land revenue resources. So if the OESL becomes a division of the Lands Commission responsible for ground rent mobilization or ground rent collection, then OESL will be responsible for collecting such ground rents relating to state lands, family lands, clan lands, and stool lands, and manage it equitably just as they've been doing over the years for stool lands. We're also saying that for lease renewals, we've seen some challenges over the years. So we realized that most of the customary grants have been leases, and now some of those leases are expiring. Now, the lessees go back to the stools, the clans and families for renewals. How are these renewals done? The Land Act sought to make some provisions and says that the renewal shall be based on negotiations between the parties. That leaves a lot of room for machinations. So we are saying there should be some clear guidelines, some clear safeguards in there, because renewals are becoming a thing now, and it's even a source of disincentive for investors. Investors come to Ghana and they say they want to invest in lands. They say, yeah, we cannot give you freeholds, can only give you leaseholds. But when a leasehold expires, what do I do? What do I do? So they are very worried, and I think if we really want to encourage foreign direct investment, we have to take a look at how leases are renewed, and also for secure tenure for Ghanaians particularly, we would have to ensure that we have some guidelines for lease renewals. When you take a look at the Land Act Section 11, it seeks to discourage discrimination along ethnic origin, place of birth, and all that. But the same Land Act says that if you are not an indigenous of the particular area, you are not entitled to a freehold. So what that means is that if I'm from Ho and I buy land in Pram Pram, I'm not entitled to a freehold. I can only get a leasehold, and I'm not assured automatic renewal, but based on negotiations between the parties. That leaves a lot of room. So how do I negotiate? And if I go and they say they are not willing to collect that particular ground, I should pay some exorbitant ground, and there's nothing for me to do. So I am advocating for some clear safeguards in lease renewal processes. So with this, we are saying that this will also align with the legal, what the spirit of the Land Act seeks to do, to ensure that there is equality for all Ghanaians, to ensure that there is free discrimination amongst Ghanaians. There should be some clear guidelines. Now, particularly relating to the merging of the Lands Commission and the OASL, there has been previous attempts. The Land Administration Project sought to bring the OASL into the fold of the Lands Commission, just as they did with the Survey Department and then the Land Valuation Board. The constraint at the time was that the OASL was a constitutional body. And so for that to be done, the OASL, the constitution has to be amended to enable that. Looking at the bigger picture, we are thinking that the OASL being a part of the Lands Commission, because they say they have the same category of experts as the Lands Commission, we work together. And when you look at the Land Act, even for various provisions of the Land Act provides that the Lands Commission and the Office of the Administrator of Stool Land shall collaborate. That's what the Land Act keeps saying. Everywhere we should collaborate to set up customary land secretariat and all that. Currently, in practice, the administrator of Stool Lands is co-opted onto the board of the Lands Commission, because when you look at the Lands Commission's setup, the OASL is not a member of the board. But to ensure the collaboration happens, we have co-opted them onto the Lands Commission board. But to make this more effectual, we are thinking that the OASL should be brought fully into the fold of the Lands Commission and bring their expertise in customary land revenue management and customary land management, particularly to the Lands Commission. That's our advocacy. So we are proposing that, first, let's take a second look at Article 267 to dissolve the OASL as an independent entity and develop a legal framework to merge it into the Lands Commission as a rent management division of the Lands Commission, responsible for managing state land revenues, stool land revenues, clan land revenues, and family land revenues. Then we should take a second look at the definition for stool lands in Article 295 for the Constitution to include family lands. And then we should amend the functions of OASL to include facilitating customary lease renewals to ensure that there are safeguards for expiring leases. That's all for my presentation. Thank you.
Thank you very much. This is very brief. You did it. You made all your very good points in, let me see, a record time of 10 minutes, almost 12 minutes. That's good. It leaves us about 18 minutes or 15 minutes to lunch. I think you mentioned, I was going to ask how come all of these proposals escaped lap 1 and lap 2, because I was, but you mentioned why, that the idea was that because the Lands Commission and the OSL are in the Constitution, if you wanted to fold the stool lands into Lands Commission, you have to do it by constitutional amendment. So you've answered that question. But I have a question in relation to that merger you are proposing. So Lands Commission deals with state lands. You are going to then fold into the Lands Commission a body that deals with stool lands and, based on your proposal, family lands. And then you are going to add state lands so that they can collect revenue across the chain. But the Lands Commission is not set up that way, right? It doesn't do the stool lands bit. It's not doing the family lands bit. And yet you are going to fold into it it looks a bit strange how you're going to do that merger.
All right. So the Land Commission performs other functions apart from managing state lands. We do other functions. When you look at 2674, the Lands Commission performs stool land management by granting concurrence to stool land grants. We also do stool land registrations, and that is a core function of the Lands Commission. So if the Lands Commission, the only thing the Lands Commission does not do is to collect the ground rent from stool lands. But for stool land management, the Lands Commission does all that. Yes.
At the end of the lease term, this is a very important point because you look at the social dynamics, Accra especially, but not Accra, just most cosmopolitan. Most capital areas have become quite cosmopolitan with non-indigens, living sometimes even outnumbering the indigens in these areas. And then when the leases expire, the question is, if there's uncertainty as to what happens at the end of the lease term, you could have a lot of social conflict, right? Because the indigens who feel dispossessed then make a claim at that point. They're, okay, we want our land back. I don't care whether you have a factory on it or you build your $1 million property on it, we want our land back. And if the only recourse is to the Land Act, which says go back and negotiate, but with no formula, with no guidelines as to how you reach a result, then it's going to be a big problem, right? Do you have very specific proposals on, I was hoping that the Land Act would deal with that problem. It solved it only partially, because without clarity as to what you plug into that negotiation, maybe you could have had a statutory formula, you could have something, an ally that really creates something that's binding on the two parties, some fallback option. If you fail to negotiate, this is what applies. Is there a way we could solve that problem? Because I think it's a big possible social conflict waiting to happen, especially in Accra, but in other places too, if we don't have a formula that solves that uncertainty about on what terms do we negotiate, how do we come to a result when the lease term expires.
So we lost the opportunity when we were drafting the Land Act. I think the Land Act should have cured that strictly. But we are... So at the Lands Commission, we had a thorough discussion on some of these issues. And some of us are of the opinion that if somebody goes and gets, particularly Ghanaians, if you go and get a leasehold from a stool, you've been on the land tenantably, you've been doing all the things that you're supposed to do, you've paid your periodic ground rent, then we are thinking that after the expiration of the lease, there should be an automatic rollover for you as a Ghanaian. Once you've paid all your ground rents periodically, and you've been on the land, you've used the land for the particular purpose that was given to you, there should not be a need for you to pay any particular lump sum to the customary land owners anymore, but for you to just atone tenancy to them and respect their superior interest in the land by paying the periodic ground rents. That should be fine. Into the ground, yes. Once you've been paying, you have been a good tenant, using the land for the particular purpose for which you've been using it. Otherwise, what we'll be creating is that people are going to be extracting exorbitant fees for lease renewals.
Which is what is happening, of course.
Which is what is happening.
Now, sometimes I think, I have encountered this problem in the literature, in the scholarship. In even UK has had this problem. Maybe our researchers can look at this from a comparative, do a bit of comparative research for us. Kenya, I know Kenya encountered this problem because this problem exists across the board, especially in the former British colonies and in the common law countries. This problem has arisen in many different contexts where leases expire and then there is a void, exactly what happens after the lease. And there are equities on both sides, on the side of the lessor, the side of the lessee. What exactly do you do? You don't want, people have invested a lot in this asset and you throw them out. It's not economically productive. It's time is investment, nobody wants that kind of uncertainty. But I think that what is the problem is that nobody exactly knows how you solve this problem, what exactly the formula is. Maybe we have to look at what other countries do in those circumstances, what other jurisdictions have tried to do, especially in the common law area. And so I think for a committee like us, where we are looking for answers to problems, it would assist us a lot if you had some options. As a land specialist, if you had some idea how these things are done. The problem is clear. The problem for us is the solution. How do you solve it? If you could give us some options, it could be in a later paper or something, or a supplemental submission, some options that either have been canvassed on the commission in terms of internal conversations, or if you know how others have solved it, it will be very helpful.
Relating to state lands, what we do at the Lands Commission, when someone gets a state land lease and the lease expires, you apply to the Lands Commission, and then you attach a valuation of the investment you've imbibed into the development of property. You attach a valuation of it. When you bring it to Lands Commission calculates what we call the premium. The premium is a lump sum payment of the accumulated ground rent over the period. So normally it comes to about 25% of the land value, and it will make you to pay that as a lump sum. So for instance, if the land value is 100,000, you may pay about 25,000 as a lump sum to the Lands Commission, and then we just revise your ground rent a bit up for you to pay. We do not ask you to pay a full market value for the land. But we realize that in customary lease, that's what is happening. So when you go to, we get a report from other areas, and we hear Alodia owners coming to chase tenants over there, then the leases have expired, and they're looking for ways to eject them from the property. We are thinking if we should apply how state land leases are renewed to customary land, that could work.
No, Prof, it seems to me that if government had looked at holistic development of our country, we would not be having these problems. You come from somewhere, obviously, before you came to Accra, the capital. Why don't you also think of building houses where you come from? And why shouldn't government help you also to get your properties there? But you want to deprive the owners of their land permanently. Now we have all realized that there's no need to give freehold for schools and family. So you knew what you bargained for. That was a lease. What are you now talking about? You want the lease to be changed into a freehold? Is that not what he's suggesting? Automatic renewal. You never finish. It's automatic. Every time you are there. Yeah. That is what
once
you are
you
doing.
keep paying, yeah.
This is the point. No, but why? Why? Are those people living here not also growing in population? Don't you also need their land to give to other people? Why? Yes, go also build at your places also. Let government also build estates in wherever you come from. We are hearing of a new development of Eastern region and Volta region going to be developed to decontest Accra. That's the best thing that ever happened. They should go. Take their lands also and develop it so people will stay. I mean, it's not fair to some of us. It's just not fair. Where do you expect our children to also go and build?
We made a bargain at independence to have a unitary state.
Yes.
Right? We made a certain bargain.
It's now more of detriment. There is no benefit anymore.
You should have joined those who wanted federalism. You didn't.
You see, we should. Obviously, we should have done that.
But in
so
hindsight,
I'm not going to support this kind of idea, going by the back route to take the land and make it free.
But there are benefits that come with also being the capital, right? You get benefits. So you take the bitter with the sweet.
In terms of population, we have completely be overwhelmed.
You are talking about you go and turn water, then it
yeah,
comes.
that was what.
Don't you like that?
That was in those days. That's what I'm talking. Not today. Not today.
Okay.
So please,
any other questions? We have 7 minutes for lunch.
Just wanted to.
I was just wondering, one of the institutions that a lot of Ghanaians have issues with their service delivery is the Lands Commission. So the process is tedious, it's painful, it's expensive. I'm just really not sure about adding even more, expanding their mandate as is being advocated. I'm not sure I can see a case for that, really, which is essentially what you were doing.
I'm thinking the idea is to create a one-stop shop for all land services to be delivered. For instance, my lordship's case where she had to go and pay her ground rent, she went somewhere thinking she was going to pay to the Lands Commission.
My point is, even the half we've given you, you've not managed it well. Now we should add more revenues for you to collect. How effectively, and shouldn't we be thinking of passing on those services, rent collection to the district assemblies, so that we strengthen them because they really have that mandate? Why should we be passing on that to the Lands Commission?
So rent management is land administration. So if we are supposed to manage lands, then we are supposed to collect land revenue as well. So the argument is that OASL, performing that function very well in customary land administration, I can confidently say that the Lands Commission has been doing so well as well in acquiring ground rent revenue from state lands as well. If I should present the figures, we are doing very well, and that serves as a huge source of non-tax revenue to the state. So adding the mandate of the OASL to the Lands Commission would only seek to enhance what the Lands Commission is already doing very well in terms of ground rent mobilization. The OASL should be added to the Lands Commission as a division, customary land rent management division of the Lands Commission.
Yes. Thank you, Chair. And still on the issue of tenant security and what should happen at the end of the lease. And I think all this has come about because of our magazine, Quid Plantato Solo Sedit. That is, whatever is fixed to the land becomes part of the land. So at the end of the tenure, you have to leave. The solution I have employed and appears to be working is to ensure that in the lease, you have that clause that gives you the option to renew at the end of the lease. And that depends on how well you bargain with your grantor. And so far, it's working. You have a lease for 99 years, and there's a clause that says that you have the option to renew for a further 50 years, and so on and so forth. So that is a way by which people are getting around the solution.
But isn't that, I mean, the contractual solution doesn't solve the problem we are talking about, right? The problem is not that the lessee cannot contract for renewal. The problem is the terms upon which they renew. And what usually happens is that when the lease expires, the lessee is now at the mercy of the lessor, and the lessor can demand something so exorbitant that there is no negotiation, right? So a chief comes and says, fine, we are renewing, but it's going to cost you $2 million. What do you do? I mean, and that is negotiation. Starts if you are like Trump, you know, the chief who is like Trump, Chief Trump, says 10 billion. What are you going to do? You've contracted for renewal, it's fine, but it doesn't solve the problem we are talking about, right? The problem is the absence of the term on the basis of which you renew. And that one, you know, Honorable Ikotu says, no, go back to Ashdown and go and find. And then you are also saying, so the problem is not solved, right? And I think you gave us the formula for how the state does its land, which is very helpful, actually, to know that the state has a formula by which it does that. You know, whether or not that's the only way to do it, I don't know. But, you know, I hear that the people say we should eat now or forever. So maybe we can proceed to lunch and then. But tomorrow is also a session for land and natural resources. It's a different set of actors, but you are certainly invited to join again, and then we can renew this conversation. We might go over some of the same issues. But I'll also invite you, because there's some overlap between what you're talking about and local government and decentralization, especially the Office of Stool Land. You know, some of the things you are talking about are also things we would we just reflect on what input you could make into that area as well, because these are very local things. Thank you very much for participating. Thank you. We have an